Well, what is the problem?
Chair, he seems to be having problems with Zoom.
What is the problem with Zoom?
It doesn't, I think he's not familiar with it. He usually uses Teams, so he's struggling.
But we have never used Team as the committee. We've always used Zoom, and he is always logged in.
He just informed me now that his laptop is still installing the app.
Can we start with Cannabis? Then he will have to present after we have dealt with Cannabis. Is Mr. Roberts in?
Mr. Chairperson, I'm in.
Oh,
Can Mr. Romano just enable screen sharing, please?
Yes, before, let's just deal with the issues of the apologies.
Recording in progress.
I know Honorable Swart will leave early. We have received his apology. We have an apology from Mr. Honorable Janje, who is in one of the subcommittees of the Magistrate Commission until the 14th of June. And then we have the outstanding apology of Honorable Maseko Jele. She will be joining us tomorrow. Are there any other apologies, members? And then also of Honorable Ramulubeng. She will join us late. She is starting with the Home Affairs Committee. They are voting for the election of the IEC commissioners. Are there any further apologies?
Chair, it's Glynis. I'm going to be on 2 devices because I'm driving to Parliament and I don't want to lose connectivity.
Okay, thank you very much. Any other apology or apologies? None. Thank you very much. Let's start with the Cannabis Bill. We understand that when Mr. Roberts and his team, they were working under very difficult conditions because also at some point they had to evacuate because of fire. And so he will take us to the extent that he has been able to work to finalize or not to finalize the bill. But if there are still outstanding issues, we would understand because we're informed that especially yesterday that it was difficult for them to work. And that would also apply to Mr. Dupree when we deal with the land court bill. But they will take us through to the extent that they were able to finish or not to finish. So we'll see how far we go. Over to you, Mr. Robertson.
Hello, Mr. Chairperson. Can everybody see the document?
Not yet. Committee Secretary, can you disable everybody else? The interaction for today is between us and the department, and to some extent the parliamentary law advisors. We don't want to see any further communications, people using our chat box. It's us and the department. Can you disable all other communication from any other person not authorized to do so? Mr. Roberts said we can't see the document as yet.
Available now?
It needs to be opened, say Cannabis for Private Purposes Bill, but it has not yet been opened.
Chair, they just need to click on the document to open it.
Yes, just click on the
We did.
document.
Okay, let's try again, Mr. Chairperson. Challenging with available
Yes.
now?
Yes, it is.
Okay, thank you, Mr. Chairperson. If I may proceed, I must apologize. The document is not completely refined. It will be ready by tomorrow, I hope. Depends if I can get access to my laptop, which is still left in my office at work. So this was a kind of reconstructed document that I put together during the course of yesterday. I did indicate the extent to which the comments is dealt with in the document. I did consider 25 submissions so far. There is 2 submissions that I did not cater for and which I will address separately, and that is of Van Zyl and another firm of attorneys. I will deal with their submissions separately after the end of all the discussions. I must say, although the committee actually indicated that submissions will be limited to certain other clauses, one must take into account that if one look at, amongst others, clause 1B, it also extends to almost each and every other clause of the bill. And some people commented outside the allowable limits that were set. But I did deal with all those comments, and I'm going to discuss them. Some of the comments may facilitate the further development of the bill. Started general comments. First comments that were received, that of which I'm going to deal with, is that of AfriStar. And obviously, the lack of public consultation, the bill is criticized. We acknowledge it, that the bill was not made available before or during its development. That's my submission. It was adequately catered for during the parliamentary process. Must indicate that although it's preferable to make or consult on a bill before it's introduced in Parliament, there's actually no obligation. Sometimes it's better to introduce a bill in Parliament due to the fact if there's issues that concerns policy issues that can probably more easily be resolved in Parliament. It's a submission that the equitable human right approach should be used to regulate cannabis. I did discuss the ambit of the bill previously. That is set out in the Minister of Justice. This is Prince. I will refer to this judgment as the Prince judgment hereafter. The main aims of the bill is to address the constitutional impermissibility of sections 4B and 5B of the Drugs Act, insofar as it relates to the right of privacy of an adult person to use and possess cannabis in private for his or her personal consumption in private, and obviously to cultivate cannabis in a private place for personal consumption in private, in the following context, amongst others, that Parliament must determine an appropriate amount of cannabis for personal use. Any activity in connection with cannabis cultivation by an adult in a private space for his or her personal consumption in private must not be criminalized. That Parliament must set a permissible limit on what can be used. And it was also indicated, obviously, in terms of the cultivation, that cultivation of cannabis plants should not be limited to cultivation at a house or a private dwelling, but this extends beyond that space. The Constitutional Court did limit the use, including smoking of cannabis in public or in the presence of children or non-consenting adults. The Constitutional Court did indicate that dealing in cannabis is a justifiable limitation on the right of privacy, and that the use and possession of cannabis in private, other than an adult for his or her personal consumption, is not permitted. And obviously, in light of the comment that was made, amendments to the bill, amongst others, seek to further accommodate culture or religious communities, and also the use of cannabis for palliation and persons who aims to self-medicate through cannabis. But the main thing is to concentrate on the allowable extent to what this bill aims to cater for, and that is the aforementioned. It is again raised that the bill should be dealt with in accordance with Section 76 of the Constitution and not 75 of the Constitution. It's our submission that the current bill, if one looks at the aforementioned, and mainly the Prince judgment, that it is an amendment to the Drug and Drug Trafficking Act, and that it should be dealt with in terms of Section 75. Although, due to the fact that we do accommodate cultural and religious communities, may to an extent change the ambit of the Act, but that can be catered for due to the fact that the bill is going to be referred to the National Council of Provinces. And to that extent, it can be addressed. It must be pointed out that most of the comments that were received again indicated that the bill is unjustifiable limitation due to the fact that it does not authorize commercial activities. It's my submission that the bill must strictly be interpreted in the context of the Prince judgment only. I will discuss some of these aspects in more detail later. There was a comment by Afristar that the bill had numerous unforeseen and unintended consequences when interpreted with other legislation. The commentator did not precisely indicate what this unforeseen and unintended consequences were. And it's my submission that in light of the discussion of the Prince judgment above, the bill must be seen as to deal with the Prince judgment issue. In terms of this reading in, it's quite clear what the department must do in terms of legislation that gives effect to the Prince judgment. It must be pointed out, amongst others, that the current criminalization in terms of the Drug and Drug Trafficking Act, so far as it relates to dealing in cannabis, is still in place. This was not changed by the Constitutional Court. So in general, one may say that dealing in cannabis is prohibited. It's a remark that the bill lacks or reflects a lack of understanding of cannabis in general and its economical potential for people in South Africa. I think it was previously discussed to the extent that, yes, it is acknowledged that cannabis has a big potential economical development potential for South Africa. But again, I did just indicate that the bill is limited in application to the extent that the bill can cater for commercialization. It has been provided for. The new proposed clause 1 deals specifically with commercialization. Commercialization is not the mandate of the Department of Justice. We cannot promote legislation regarding commercialization. We cannot administer it. And there's a lot of other issues that falls within the domain of other departments that can better be addressed by that departments. And the departments involved have been identified. It's the Department of Health, Agriculture, and Department of Trade, Industry and Competition. I must refer to the Cannabis Master Plan, which actually propose or make suggestions that appropriate departments that must deal with cannabis commercialization is, amongst others, the Department of Health and Agriculture, and obviously the Department of Trade and Industry, due to the fact that they already administer the liquor legislation in South Africa. So yes, we acknowledge the economic potential. I think the department did previously when it dealt with the possible models for cannabis regulation, provided a document to the committee, setting out the options of commercialization, as well as the options for cannabis regulation. And in that document, it was indicated that, yes, we can, through commercialization to a large extent, regulate cannabis harms. That is acknowledged. There were problems that we indicated, amongst others, that we are kind of bound by our International Drug Convention obligations. That will also be discussed later, but I can more or less indicate that that actually restricts South Africa to utilize cannabis for commercial purposes. Since in terms of the 1961 convention and the other two drug conventions, the substance in question must be restricted and must be regulated. So it's only available for medicinal use. And it was indicated that, yes, various other countries did stand down from their obligations on a basis of a harm reduction measure to regulate cannabis. And I believe approach to balance these obligations with economic commercialization was also discussed. The indication that the bill prefers criminalization over commercialization with any consultation on the matter. Not going to discuss this in detail, but I must indicate again, the bill must be construed within the context of the Prince judgment. I must again point out that the Department of Justice cannot promote legislation to deal with commercialization. And if one dissects the bill and regulate, or rather compare it with the legislation of other countries, one will see that the kind of regulatory framework that is set out in the bill, namely the restriction that is imposed on cannabis activities for private use in terms of clause 2, and the enforcement mechanisms that is used in clauses 3, 4, 5, and 6 to ensure compliance is substantially similar to that of legislation of most foreign countries, which in addition to the legalization of cannabis for commercial purposes, also regulate or allow private cultivation and use of cannabis. I must indicate that further that if one look at the prescribed quantities, it's extremely liberal if we compare that with the other countries or foreign jurisdictions. Actually exceed the amounts many times in some instances. And I must indicate that this notion that criminalization over commercialization seems to be the preferred way how to deal with cannabis regulation does not take into account that even if we look at the Tobacco Control Act, or liquor legislation that's currently in place. Many of the aspects that is catered for in the bill is to an extent applicable to tobacco and liquor. And there is regulatory measures in place in terms of the tobacco and liquor legislation to regulate that through criminal sanctions. Although there were not prior consultation on the bill, in light of the aforementioned, that and due to the fact, obviously, that the bill give effect to the narrow ambit of the Prince judgment, my submission is that criminalization is justifiable. And yes, commercialization can be used as a harm reduction measure and to control harms associated with cannabis. But again, commercialization cannot stand in vacuum. It's limited and must be enforced through criminal measures to ensure compliance with any regulatory framework that provides for commercialization. So, to an extent, I think it's an unjustifiable comment. And the issue that the bill aims to regulate cannabis is a criminal issue rather than a social issue. Favors alcohol and tobacco, which are more harmful than cannabis. I already indicated the necessity for criminal enforcement mechanisms to control the personal use of cannabis. And I did indicate, amongst others, that yes, even alcohol and tobacco are regulated. And it's not very dissimilar to what is intended by the bill. The only real issue here is, what is the harmfulness of cannabis? And that's quite difficult to determine at this stage, but I will indicate in a later discussion that cannabis must at least be considered to have the same harm potential than alcohol. Although there is some people that regard it as less harmful, one must take into account the fact that it is a psychoactive substance. It has got a narcotic effect similar to alcohol. And alcohol is already regulated. It can be restricted to a large extent through the current regulatory framework in place, which does not exist for the so-called private use of cannabis. And there are many restrictions on alcohol that is aimed to criminalize it, and with the aim of harm reduction. So to the extent that it favors alcohol over tobacco, my submission only relates to the penalties that can be imposed. In terms of the bill, the penalties that may be imposed can arguably be regarded as more severe than those for tobacco and alcohol. But in the document tomorrow, I will discuss the proportionality of the various penalties vis-a-vis those in the bill and that of alcohol regulatory measures. RCSA, amongst others, indicated that cannabis must be available to all without any restriction, regulation, or limitation, and that they reject the bill in its current form. Cannabis regulation is, in our opinion, necessary to protect others against the harms associated with cannabis, and a need has been identified for regulation. There was an email that was circulated, amongst others, also to the committee. It was from a Dr. Scott, and it made a policy document of the Transform Drug Policy Foundation available for everybody. There was previous criticisms that the department do not consider each and every document that was submitted to them. So to that extent, I aim to deal with each and every aspect that has been raised, including documents of that was endorsed by certain parties and submitted to the committee. It's indicated, amongst others, that Transform Drug Policy Foundation is a world leader in drug law reform, and it's very indicated that its applications or publications have been used extensively by many countries, and it has influenced many countries to reform their drug policies. And the guide that was made available contained various issues, or discuss that and make recommendations that is very relevant to the bill. And I will refer to the third edition that was distributed. In the document, certain models for cannabis regulation are considered. And this indicated, amongst others, that cannabis regulations should have the following key aims, namely to respect, protect, and promote human rights, protect and promote public health, promote social equity, improve development opportunities, ensure communities most impacted by the prohibitions are included in policy development, must further aim to reduce crime, corruption, and violence associated with drug supply. In some of these aspects falls probably outside the strict and narrow ambit of the bill, but I do discuss it since the bill intends to authorize commercialization activities through other legislation. And it is indicated, amongst others, in that context that it must limit the incentive for profit-making driven problematic use of cannabis, must protect the young and vulnerable from potential harm, must incorporate clear outcome indicators and measures of success, or rather measures to evaluate success and obviously failures. That is further discussed in that document. And it was evaluated against the provisions in the bill. And it's my submission that the bill gives effect to most of these policy aims, even insofar as it tries to facilitate commercialization through other legislation where there is specified harm reduction measures included in what other legislation must take into account. Further in that document, there's a summary of different regulatory models. And there is a model that deals with prohibition on the production and supply, with decriminalization of possession for personal use. And there is a model that, amongst others, deal with prohibitions on production and supply, with decriminalization of small-scale personal use cultivation without social clubs. To a large extent, and even in terms of the previous options of cannabis regulation that was discussed, there was an indication that the bill gives effect to some or rather intends to implement similar models of cannabis regulation to those discussed. In terms of further recommendations in terms of this policies, amongst others indicated that expungement should seriously be considered if there's reform in cannabis legislation. That's expungement of previous criminal records. And it's my submission that the bill do provide for expungement of criminal records. The guide further indicate that impaired driving laws should, amongst others, deal with the driving under the influence of THC. And a clear indication that is given in terms of that guide is that there is currently no scientific consensus regarding the blood TH concentration that correlates with unacceptable levels of driving under influence of cannabis. It's indicated, amongst others, that this THC level concentration should be set in the range of between 7 and 10 nanograms per milliliter. This is above what is proposed in the bill, but they only indicate that this is a sensible starting point. But they also do indicate that driving under the influence of both alcohol and cannabis simultaneously need to require a lower blood THC content. Insofar as it relates to synthetic cannabinoids, it is a clear indication that synthetic cannabinoids should not be catered for in terms of a cannabis regulatory framework to exclude it from criminalization. And they indicate that the de facto positions should be that cannabis, synthetic cannabis, should be criminalized. So to a large extent, it's my submission that the bill do give effect to this policy. There is differences, but it's substantially addresses most aspects that needs to be addressed as was proposed by them. RNCSA, amongst others, indicate that the bill should be renamed as the Cannabis for Private, Religious and Commercial Purposes Bill. It's my submission, there's no need to rename the bill. The bill is still cannabis for private purposes, although it does accommodate cultural and religious organizations. It definitely doesn't make provision for commercial aspects, and there's no need to change the name of the bill. It's indicated that government should apologize to the victims of the criminalization of cannabis, which is now considered useful. And it's my submission that it is a change in policy that resulted from a declaration in the Constitutional Court, considering developments in foreign jurisdictions. And really, there's no need to apologize for a rights-based interpretation that authorizes substance to an extent, but also aims to regulate it further. And that is done in terms of the Prince judgment, which restricts it to personal use only. And my submission, there's no need for to accommodate the submission. It's again indicated that the bill should be rejected, amongst others, for lack of participation, rather lack of public participation and consultation with interested parties. Interesting issue that is raised here is that the current legislative process do not allow for meaningful participation of poor and uneducated persons who are primary users of cannabis and who will be most affected by the bill. Again, I already indicated that the bill was not made available during its development, and public participation can take place in Parliament. The rules of the National Council of Provinces deal specifically therefore, and in any event, this bill will go to the NCOP, which will allow for a more community-based approach in consultation in the provincial legislatures. Again, CVC indicated here that activities regarding cannabis should not be restricted. I must refer, amongst others, to the Foodstuff and Cosmetics and Disinfectants Act, Tobacco Control Act, liquor legislation, the Medicines Act, and there's a host of other legislation that's applicable here, which regulate almost each and every other aspect that can be consumed by humans. And there's a need, therefore, it's obviously to protect humans against adverse harms, or rather, it limits harm and ensure that the product is usable for human consumption, and it do set certain specific requirements that must be complied with. And even if one goes outside a Prince judgment and try to evaluate cannabis as a recreational commodity that can be distributed whatever other legislation may come in place will regulate this aspect in detail. This is done in each and every country that legalize cannabis for commercial purposes. Even in respect of hemp, for industrial purposes, there's a host of regulatory measures that applies thereto to ensure that it is fit for its intended use. It's my submission that the activities of cannabis should be regulated. Currently, it's again in terms of the Prince judgment, and that is to ensure that it can be used in the private space by an adult person. Medicinal use of cannabis is authorized in terms of the Medicines Act, but it's subject to licensing and regulation. And there is initiatives, amongst others, by the Department of Agriculture to also, in terms of the Prompt Improvement Act, to make, especially insofar as it relates to cultivation, certain specific cultivars available. So that, per se, imposes restrictions on how we deal with cannabis. It's indicated that the department previously, amongst others, as a result of Judge Gordon and recommendations of civil society, indicated that the general recommendation is that cannabis should be regulated the same as alcohol and tobacco. And CDS-CSA indicated that they do not see the practical implementation of these previous proposals, and that cannabis is still regulated differently from tobacco and alcohol, and subject to a stricter regulatory framework. And they do indicate that this amounts to fair discrimination of users of cannabis. I think this issue has been discussed previously to the extent that there is regulatory measures in place for tobacco and alcohol. The bill, to some extent, implements similar measures in respect of cannabis. It is acknowledged that the legislation that applies to liquor and tobacco products imposes less serious penalties. But I must also indicate that tobacco legislation and legal legislation do have certain measures similar to those in the bill to address harms associated with cannabis. There's an aspect that needs to be considered by the committee, and that's discussed next, paragraph 1.7. It indicates, amongst others, that the bill entitles individuals to use and cultivate recreational cannabis. Yet it does not make provision to legally obtain cannabis. And the continued criminalization of the sale of recreational cannabis will actually fuel illegal activities in respect thereof. There's also a further indication that some of the offences that is created in the bill is to the extent that it can be considered discriminatory against certain persons who, amongst others, do not have a private place to cultivate cannabis plants or a private place to use cannabis. This is directly as a result of the comments that were provided by Grisha and also SAAI, and there's also other comments that will be discussed later on, and that is of SADPI, that do indicate that to an extent the provisions of the bill may be regarded as discriminatory, since they do not allow full use by adult, or rather of cannabis, to exercise his constitutional rights. I must just again in this regard remind the committee that the guidelines for this bill is still the Prince judgment. It's my submission that the department should to a large extent abide by this judgment, and obviously the department cannot promote legislation that will, amongst others, allow for commercial activities of cannabis. And this has been discussed before. I must also indicate that to the extent that the bill can provide for commercialization, it has, and that is amongst others that it remove DAGA from the Drug and Drug Trafficking Act, which is one of the pieces of legislation that deals with our international convention obligations. And that allows cannabis to be regulated by other legislation that can provide for these activities. And the bill even goes far as to facilitate commercialization. Insofar as there may be discriminatory measures, since there's unjustifiable restriction on the exercise of the rights of allowed by the Prince judgment, insofar as it may impact on persons that do not have adequate space to cultivate or use cannabis in private. This is acknowledged to an extent. It will be discussed later in this document. But the main issue there is, how do we provide or try to cater for each and every person that has a problem or perceived right infringement in a bill of this nature? It's my submission that it's close to impossible. And there's restrictions and limitations that need to be imposed, but that restrictions and limitations cannot accommodate each and every other person. It will be dealt with later, amongst others, when the proportionality of the penalties and the proportionality of the offences is discussed. It's indicated by CCL, the CCL, Child Law Center, that they actually do comment the provisions of the bill to the extent that it places obligations on adults to, amongst others, ensure that children do not use cannabis. And it's indicated that, yes, it's acknowledged that the bill gives effect to the Prince judgment, but that the subsequent State versus Allen judgment has not fully been accommodated in terms of the bill. And they do make certain proposals later on in the discussion, what should be accommodated to address the general clarification that was provided in the State versus Allen judgment, how cannabis should be regulated in terms of children. And it's indicated that the constitutional correct approach that was set out in the judgment is to the effect that cannabis use or abuse by children involves treatment, awareness, education, to equip communities and individuals with relevant tools to deal with cannabis abuse. And it's acknowledged that, yes, the Allen judgment was decided subsequent to the Prince judgment. And to a large extent, we do accommodate some of the recommendations that is made by the Child Law Center in this regard. It's also further indicated that although the LM and 3 others judgment related mostly to a declaration of the children's right in respect of the possession of cannabis by adults, vis-a-vis the offense of possession of cannabis by children, which the Prince judgment excluded, was declared unconstitutional due to the fact that this amounted to a status offense, since it criminalized possession of cannabis in respect of children, which is uncriminalized in respect of adults. Okay, then there is a remark by Callanan to the effect that it mainly relates to the enforcement of the bill. That's discussed in paragraph 1.9a. And it, amongst others, indicate that it's quite complex if you look at the various definitions that impose something like height restrictions, concentration limits, etc., on aspects that needs to be enforced. It is indicated here that it will be far more sensible to differentiate between cannabis at a level, or okay, let me rather start again. It is, amongst others, suggested that it will be more sensible to address cannabis and regulate it at a level that takes into account for what it will be used, and that harm must be used as a core focus in this regulation process. It's my submission that, yes, the bill is complex, but this is needed. I must remember that the bill affords rights to certain individuals, and the rights that is afforded are strictly regulated, amongst others, to certain specified quantities. And those rights and quantities are enforced by criminal law. And in the criminal space, legislation that aims to regulate this must be extremely clear. Otherwise, it will be struck down in most instances. Must be indicated that to differentiate cannabis at the level at which it is, for which it will be used, is to an extent not applicable here, since the whole objective of the bill is to regulate private use of cannabis, and that there's no other intended regulated purpose, and it must therefore be restricted to that objective. It's further indicated that criminalization is again something that's quite flawed in the regulation of cannabis. I think this has been discussed previously. I'm not going to discuss it again, but to a large extent, I cannot fully agree with the sentiment that was raised by Kalinin. Must further be indicated that yes, if it's cannabis regulation that takes place in a commercial environment, there may be some other options that can be used to further regulate it, amongst others through administrative or civil enforcement mechanisms. In the context of the bill, this cannot apply. The criminalization as an enforcement mechanism is needed in this instance. It's my submission that if one look at most legislation in the statute book, we'll find out that other than in a commercial environment, criminal law is used as an enforcement mechanism, and that applies and cannot be applied. Sorry, criminal law is used as an enforcement mechanism, and it's only in rare instances that other enforcement mechanisms, such as administrative penalties or civil penalties, can effectively be implemented, and can, in most instances, in any case, only be implemented in a regulated commercial environment, and which the bill is not. There is a submission that's discussed in paragraph 1.10 that, amongst others, indicate that the bill does not take into account the practical ramification of cannabis decriminalization in South Africa and its impact on the South African education system. It's also requested that specific provisions must be incorporated in the bill to deal with school-going learners over the age of 18 years, and that there should be measures in the bill to protect the school system in general from cannabis abuse. That is to protect other educators or learners in that environment. It's further indicated that the manner in which the bill aims to regulate the cannabis matter is a measure that is unsuccessful in most other countries, amongst others, the United States. They also indicated that specific aspects that's not regulated in the bill is that of learners that's over the age of 18 years, who is under the influence of cannabis on the school premises. The fact that school staff and members of the public may smoke cannabis near and on school property, and according to the author, this can be done legally. It's also further indicated that the public will be entitled to sell and smoke cannabis near schools, and will do so in the presence of school-going minors. It's also further indicated that the decriminalization of cannabis will increase its availability and use by learners. Aspects that's apparently not addressed is liability for injury and damage to property resulting from cannabis intoxication on school premises or in schools. According to the author, dealing in cannabis in schools is a problem that is not appropriately addressed. It's further indicated that possession of cannabis by a person 18 years or older, including teachers on school grounds, can easily be explained away to the effect that they possess the cannabis legally for personal use. And I think one of the issues here is that the author, rather the commentator, perceived the bill as the instrument that gave rise to decriminalization. And this is a misperception. It's not the bill that decriminalized cannabis. It was the Prince judgment that decriminalized cannabis. So that is an aspect that needs to be corrected. The bill only gives effect to the Prince judgment. Some of the issues that is specified or as not addressed by the bill is obviously addressed by the bill. Amongst others, that it limits the availability of cannabis. It restricts the places in which it may be possessed. It restricts or limits the places where cannabis can be consumed or smoked. It addressed dealing in cannabis. An array of other aspects that is apparently not addressed. So that is incorrect. Must further refer the author, or the committee rather, in this regard, to the fact that the South African Schools Act do provide for appropriate measures to further regulate cannabis in context of, amongst others, high schools. As far as the bill itself does not regulate an aspect, it may be regulated through a code of conduct in terms of Section 8 of the South African Schools Act. Regarding the possession of cannabis on school grounds, Section 8 of the South African School Act, amongst others, prohibits learners to bring or possess illegal drugs in school premises. It provides for the search and seizure of legal drugs. and it also provides for disciplinary proceedings that may be instituted against a learner that's in possession of illegal drugs. It's my submission in that context that the bill do adequately cater for most of the aspects. What the author further indicate, among others, and this can also be applied to the proposed commercialization of cannabis, is that they've worked with 18,500 drug users over a period of 9 years. And in South Africa, cannabis is used, amongst others, as a component of Nayope. And Nayope is a mixture of cannabis and heroin that is smoked. And they do indicate general availability or use of this drug or cannabis by the youth of South Africa of a school-going age. According to them, there is a link between the use of cannabis and the progression to harder drugs. And an aspect that was probably not further clarified in the summary is the fact that the availability of cannabis under the decriminalized position does ensure that cannabis is more freely available than ever before. It's among others indicated that although commercialization can to an extent address some of the harms associated with cannabis, and also the regulation in terms of the bill that restricts cannabis to further regulate harms, will only be partially successful. And that is to the fact that in their perception, cannabis is a gateway drug, and obviously give rise to further drug use of harder drugs. And according to them, this harder drug use will place, or rather will increase criminality, which to an extent will also then increase the demand on the SAPS and the criminal justice system of South Africa, which was previously discussed as aspects that can be negated through a commercialization. The only real answer to this that I can provide is that yes, it's well acknowledged that Nayope and is a drug that is extensively used by the youth in South Africa. Cannabis is involved in the substance that's smoked, but according to available literature, cannabis is not per se a hard drug that will give rise to increased use of other more dangerous drugs. But in light of the extensive experience of the commentator, its input is valuable to an extent. But again, academic discussions in this issue is to a large extent that cannabis will not per se give rise to increased use of drugs or even the use of more dangerous drugs. So again, criticism that the South African Teachers Union were not consulted in the preparation of the bill. The response there too is that it's correct that the Teachers Union have not been consulted, and discussion was already provided that it's not an absolute requirement, and that the bill is currently in Parliament and is subject to a parliamentary consultation program. And obviously, something that must be kept in mind is
Mr. Robertson. Mr. Robertson.
Mr. Chairperson.
Yes, I'm afraid at the rate at which you are going, because you also repeat some of the responses you have given to other comments. Is it not possible to really package comments that were made under this, and then what is the response of the department? Because I don't think that at the rate at which we are going, we will be able to finish this bill. Because I also think that we start arguing also some of the things that we are still going to argue down the line. So I think let's find a better way of ensuring that we respond to everything in a manner that is substantive, but let us not be repetitive, and issues that we are still going to respond to them, let us not respond to them when we start, and then we're still going to come back to them.
Mr. Chairperson, it is correct. I can, to an extent, limit it, or rather throw everything together. That was done in another document, which is not available since I cannot access my laptop at work. I'll try it from memory to skip certain aspects which is already dealt with. But one must remember that although the lack of consultation is criticized, in this respect, it relates to the teachers' unions. The other ones relate more or less to cultural and religious communities. But I will try to more or less group everything together. Okay, there's a reference that cannabis will increase motor vehicle accidents, and law enforcement is not adequately equipped to deal with driving under the influence of cannabis. Explanation is given to the effect that yes, it's acknowledged that cannabis will increase driving under the influence. There's amendments to the National Road Traffic Act. And to an extent, the law enforcement agencies needs, at this present moment, already deal with driving under the influence of a narcotic substance. And the question is asked that the context of the bill, and insofar as it aims to implement the Prince judgment, the question is asked whether there was any research on decriminalization of cannabis in a South African context. It's probably not necessary to answer this. The bill ex post facto try to address a resultant legal position is not the actual instrument that facilitate decriminalization. It's indicated by the Department of Defense that the bill does not apply to the South African National Defence Force. But then they also alternatively request that members of the South African National Defence Force should in certain instances be excluded from the bill. It's my submission that other legislation already provide for the exclusion of members of the South African National Defence Force from the provisions of, let's call it civil or rather criminal offences that applies to civil members of society. And the bill should not address this, accommodate it, or even try to address this.
Ngomhla we-30 kuMarch kulo nyaka apha kule bhodi naba abantu
Okay, the submission in paragraph 1.12 was already discussed or similar to a previous one. It's not going to be addressed again. I think the submission of FGA has been discussed to a large extent previously. I'm not going to discuss that. I'm not going also to discuss the various aspects that relates to the submission, but important aspect that has been raised in this regard is to effect, amongst others, that the bill is not evidence-based and aims to regulate cannabis on the basis of perceived harms of cannabis. It's probably necessary to discuss this, although it was referred to previously. And this indicated, amongst others, that THC is included in the drug conventions, subject to regulation in almost all countries, either as a psychotropic substance, a medicine, or a substance authorized for recreational use. And if you look at the relevant available academic literature, cannabis is at least a substance with narcotic and mood-altering substances. Quite a long discussion that is provided from year to year. I do indicate that there is a certain, let's call it, adverse consequences on the human body and brain if you use cannabis. And the perceived harm aspects that the bill then aims to achieve is to address this adverse effects of cannabis on humans. It's indicated, amongst others, that yes, it's not currently clear what is the potential harm, or rather the extent of the potential harm that cannabis may pose, but there is indications that it is similar or slightly more or slightly less harmful than alcohol. FGA, amongst others, referred to the guide that they developed. I'm not going to discuss this in detail. It is available to the members of the committee to consider. One aspect that needs to be addressed here is the fact that under the constitutional right pillar, cannabis clubs is, amongst others, discussed as an appropriate solution to facilitate the exercise of rights of certain people who do not have access, amongst others, to space, a private space to use or cultivate cannabis. The committee has previously considered cannabis clubs, and there was indication that it is not a viable option in South Africa, and that the main problem with the implementation of cannabis clubs in South Africa is the fact that it is not subject to effective regulatory system. But it must be taken into account that this is probably a mechanism that can be used to address the non-availability of a private space. I'm not going to discuss the adult use commercial pillar. The last comment on the general comments is indication by SADPI that they do appreciate the fact that there is a reduction in penalties and to new proposals that has been proposed by the bill. But they do note certain concerns, which I will discuss later. And that relates directly, amongst others, to the proportionality of the offences vis-a-vis alcohol and cannabis. The fact that there is discrimination to an extent, since the bill do not allow for the exercise of certain rights by persons, and the main concern of theirs is, amongst others, a disproportionality of penalties. I'm going to proceed with the comments that we received on the long title. I know there is certain words that were left out in the long title that didn't fully portray what is stipulated in clause 1B. This is a correction of the appropriate item of the long title to, amongst others, provide for culture or religious communities, and not just that of the Rastafarian faith. There is certain, let's call it grammar errors that were that have been identified, or rather it was identified, and it's discussed here. I'm not going to deal with that. It's just our submission that those will be corrected. No need to discuss it. The definitions, we did receive certain proposals in respect of some of the definitions. One of the big issues that some commentators criticize is, amongst others, our regulation of THC in terms of the definition of cannabis. Current definition of cannabis provides that it's a cannabis plant, and then in paragraphs B and C provide, amongst others, that it also includes any other substance containing amount of THC. It is referred to the fact that amongst others, that it's not evidence-based. It's quite an arbitrary approach to regard 2% THC per volume as the adequate volume of THC that a substance must possess to qualify as cannabis. There's also indication that there's a similar arbitrary determination in terms of paragraph C, which specify lesser amount of THC for certain offences. But one of the other things is the fact that some of the commentaries seems to confuse this determination with the determination that applies to hemp. It was previously already indicated, amongst others, that the bill does not prescribe appropriate amount of THC content for hemp. And the bill provides that other legislation must be promoted to regulate hemp. So the criticism that, or perceived criticism of the fact that the bill aims to prescribe 0.2% or 0.3% for hemp is actually a incorrect interpretation of the quantities or the aims of the definition, since it does not apply to him at all. There is substantial comments have been received, or rather the DOD made substantial comment on the definition of any substance containing THC. Not going to discuss it in detail. It's our submission that any substance containing THC don't need to be provided further in the bill. We do not need to provide for the manufacturing of a substance containing THC. This was discussed previously. And our interpretation is that definition of cannabis, or to the extent that it provides for any substance containing THC, need not to be clarified any further. Definition of guardian, Child Legal Center made a representation to the effect that we need to consider an amendment to the definition of guardian, amongst others, to include various other categories of persons, and they name it an appropriate person. For the purposes of clause 6.1. Okay, let me start again. Definition of guardian, there is a proposal to amend this. Clause 6.1 is relevant interpretation of clause 6.1. Clause 6.1 places certain obligations on persons to ensure that child should not use cannabis, or a person who has a responsibility over a child must not allow a child to smoke cannabis, etc. Child Legal Center wants to extend this definition, amongst others, to appropriate person, which will, according to their proposals, include any member of a child's family, including a sibling, who is 16 years or older, or a caregiver referred to in the Children's Act. Our response thereto is, yes, we can consider an amendment to the definition of guardian, but recommendations that it must include any member of a child's family or a sibling who is 16 years or older may per se provide a problem in this regard. We may criminalize the conduct of persons who is actually a minor themselves, and we don't want to draw other minors in a web to ensure that they have got obligations over other minors to restrict the latter's use of cannabis. So there will be a proposal that will accommodate this proposal partially, to the extent that it may include a caregiver as contemplated in Section 1 of the Children's Act, and only to the extent that the person who has a parental responsibility over a child should be caught into the web of Section or Clause 6.1, and this can be amended to accommodate that. Okay, definition, possession, private is discussed here. I don't think it's necessary to discuss it again. It has been previously discussed. It's mainly to the effect that if you possess, in terms of the bill, cannabis in a public place, it must be possessed in private. And I think the main complaint was against the fact that it doesn't apply to tobacco or alcohol. This is acknowledged, but again, one must consider the definition in the context of the Prince's judgment. There's a recommendation that public place must be amended. I'm not going to discuss that. Seedling, there's a proposal. I'm not going to discuss that. There's a proposal that the THC definition must remove THCHA from its ambit. This cannot be accommodated. Regarding the definitions of prescribed quantity, commercial quantity, and trafficable quantity, the only submission that can be accommodated is that of the Department of Defense, to the extent that trafficable quantity must be amended to mean that it includes the quantity prescribed in the appropriate column of Schedule 4, and not the quantity that exceeds that.
Chairperson, my apologies, Mr. Roberts.
Honorable Juan.
Yeah, Chair, we've been going for quite a while now, and I think maybe Mr. Robertson can make use of a short break also to consider your guidance a bit further. So my apologies to butt in, but would it be possible for us to possibly have a 10-minute break?
No, that's correct. I was looking at 11:15. As you would know, generally, Honorable Horn, that is the break that usually in courts they would take 11:15 in your previous life. I was looking at 11:15. But I think also on Mr. Roberts is quite tired now. If we can start at past, and then we quickly deal with the Magistrate Commission, and then we can come back to this one. I think he would have been able to think properly as how he would consider the suggestions that myself and you have both made. Will that be in order?
I'm indebted to you, Chair.
Thank you very much. Can we meet at 11:30? And Mr. Mayor, will you be ready to proceed from 11:30?
Honorable Chair, yes, I will be fine.
Thank
Can
you.
you hear me?
Yes, we can hear you.
Okay, thank you so much. Now I'll be fine. 11:30.
Sure.
Thank you, Chair.
I think he would have been able to think properly as how he would. Welcome back, Mr. Mayor. Welcome. Over to you. Mr. Mayor. Bonani, can you contact him?
Do you hear me, Chair?
Yes, we can hear you.
Thank you, Chairperson. I wish you all well.
Yes, we are.
Okay, you want to be briefed on the matter of Ms. van Schalkwyk? Chairperson?
Yes.
What is this exactly what you, because we briefed the portfolio committee somewhere in August last year.
No, we just wanted you to make a brief reminder as to what were the issues and how far are you now with those issues so that we can deliberate.
Good, Honorable Chairperson, may I just give a brief background? The Minister provisionally suspended Ms. van Schalkwyk on the 4th of June 2013. She took that decision of the Commission to charge her with misconduct on review and on appeal to the High Court. The High Court dismissed the application. The High Court dismissed the application for leave to appeal, and she went to the SCA, and all those applications were dismissed with costs.
Mr. Mayor.
So then we proceeded with the
Mr. Mayor.
Sorry, Chair. Yes, Chair.
We are on the public platform. We are not only talking to members of parliament, we are also talking to the nation. Please briefly just say what were the issues, what were the charges, what did she do, and then take the nation into some details as to what are the issues.
Okay, Chairperson, the charges, let me just get the file. Sorry, I didn't expect it to be asked about it today. I thought it was just for the review application, but let me just get the file quickly. If you can, may I just have your permission to that? Chairperson, she was charged with failing to adhere to official court hours, arriving late and departing early, improper use of a state vehicle, being rude, humiliating, belittling, threatening other judicial officers and officials at the office, being respectful to Mr. Jonker, who was the then cluster head, and the Chief Justice by using derogatory email, allowing a magistrate from a cluster court to adjudicate in a matter wherein she was cited as the first respondent to be declared indebted, over indebted. She was apparently gambling during official hours, absent from leave without cause, borrowing monies from a junior judicial officer at her office and not paying back the monies, and asking the same magistrate to come out of court to do her hair, arranging a loan application for that particular magistrate without her consent. She called her out of court to apply for another loan for 34,000 Rand to pay her son's university fees. She took her out of court for 5 weeks to do a report. And then there was also, she requested another junior magistrate, or rather a magistrate to assist with the correspondence to attorneys relating to judgments granted against her during official hours. She took Mr. Silva out of court to deal with UASA matters, Judicial Officers Association of South Africa, and to call magistrates to get support for special general meeting, and to email them in respect of JUASA. She requested another magistrate to search for banners during official hours on behalf of JUASA. She requested that particular magistrate to assist with a conference at Carnival City. She requested Attorney Malloy to pay for travel expenses to Washington, D.C., or collecting cash from him using that particular magistrate to attend an international conference for judges, which the Chief Justice, her permission was declined by the Chief Justice. She handed down a sentence written by Mr. Mawodi, that's another attorney in a matter. She made use of official parking at the Kempton Park Magistrates Court without paying. She denied presiding in a matter involving the same Mr. Malloy, whereas she did do an application where he was appearing in front of her. Well, she was failing to comply with the lawful orders of her cluster head and submitting daily court statistics. She failed to pay a rental for her apartment, and it was a reckless conducting of finances, resulting in being declared over indebted and having default judgments being granted against her. Now, she was convicted or found guilty at the misconduct inquiry in October 2020 on 13 counts of these charges, and I think the most serious one was the one which she borrowed money from an attorney to go abroad to attend a conference, which conference, well, her attendance was not approved by the Chief Justice. She was then, the presiding officer imposed a sanction in October 2020, recommending to the Commission that she be charged, that she be found guilty. And well, he found her guilty, but recommending that she be removed from office in terms of Section 13(4)(a)(1) of the Magistrates Act. And that recommendation was then endorsed by the Commission, and the Commission advised the Minister on the 17th of March 2021 accordingly. Ms. van Schalkwyk then filed a notice of motion reviewing and setting aside the presiding officer's finding of guilt and the recommendation that recommendation on sanction that she be removed from office. She cited the minister as the first respondent. The second respondent was the commission. And she also sought a legal remedy against the commission for endorsing the recommendation from the presiding officer to have her removed from office. And then the third respondent was the presiding officer. She doesn't seek in her interview in her motion application any relief against the minister. She didn't cite Parliament as a respondent. She filed that application on the 21st of May 2021. The minister, therefore, without any bar from proceeding with suspending her from office on the 27th of July last year, suspended her from office pending Parliament's decision to either restore or not to restore her to office. And then I think the Portfolio Committee had sight of the legal opinion from the parliamentary legal advisors that was dated on the 22nd of November 2017, if I'm not mistaken. With respect to the matter of Ms. Quiba, she also took the Commission, the Minister, and even Parliament on review, not to proceed with her with a decision to remove her from office. And the opinion, it was the opinion of the State Legal Advisor that Parliament should proceed, which was done, and she was removed from office. They actually concluded that using the Portfolio Committee or citing the Portfolio Committee at the time is not a justifiable basis in law to prevent Parliament from carrying out its legal, actually constitutional legal obligations imposed by the Act. The Act says that Parliament must, as soon as reasonably possible, pass a resolution either to restore or not to restore to the office of magistrate. And well, the NCOP already passed such a resolution on the 24th of November 2021. With regard to the review application, Honourable Chair and members, I filed my founding affidavit, answering affidavit in February this year. They filed a replying affidavit, and I filed a supplementary affidavit in March this year. I've just had a brief conversation with the State Attorney acting on behalf of the Minister, acting on behalf of the Commission and the third respondent. And he advised me that the applicant still has to file his core bundle in court, but it contains about 10,000 pages, and he was directed to reduce it to 5,000 pages. If that is being filed in court, then both parties have to submit their heads of arguments, and then only thereafter the matter will be heard. It's expected that the matter on review may be heard maybe in the third or maybe the fourth quarter of this year.
Thank you. Thank you very much, Mr. Mayor. Is that all?
Yeah, unless, of course, there are questions.
Thank you very much. Members, are there any questions? I think you would have received a letter from Ms. Spanskalk's lawyers. We asked it to be distributed to your good selves today. We received it, I think late yesterday, and then we've asked it to be distributed to yourselves. Honorable Hon.
Yes, thank you, Chair. I'm specifically on that letter in which it is stated by Ms. van Schalkwyk's attorneys that the review is in fact proceeding, and the one thing I think we must get some information from Mr. Meyer on is the statement that the Magistrates Commission has chosen not to oppose the review in respect of 9 of the 13 charges. So mindful of the legal advice that has been given in similar circumstances in the past, we must also then ask Mr. Meyer's reaction on behalf of the Magistrates Commission to the statement or the argument in this letter as, well, it's really just a confirmed stance from Ms. van Schalkwijk's attorneys to the effect that there would be no prejudice for us ultimately not to proceed with confirming the removal from office, given the fact that she is at this stage suspended and not receiving remuneration. So yes, I think in essence my question would be twofold. The first being, what are we to, is it factual that the Magistrates Commission has chosen not to oppose the review in respect of 9 of the 13 charges? What would be the effect thereof in the view of Mr. Meyer in respect of the decision to remove from office? If only 4 of the 13 charges would then stand. And secondly, what are we to make of the argument that there would be no prejudice to the state, the public purse, given the specific circumstances? Thank you, Chair.
Thank you. I would say, just in addition to your last question, Honorable Horn, should we only look at the prejudice in terms of the public purse? What about services that should be rendered to the people of Camptonpark? Because instead, if they had a complement of 5 magistrates, they have a complement of 4 magistrates, and then 1 has been on suspension for a very long time. So in terms of the number of cases, the magistrates or the people there are 1 magistrate short, and they're not getting the service that they would have required, that they would have received if they had received, if we had the required complement of magistrates. I was just adding to what Honorable Horn was raising.
Yes, thank you, Chair.
Thank you very much, Honorable Breitenbach.
Thank you, Honorable Chair. I'm covered.
Oh, thank you very much, Honorable Breitenbach. Honorable Mr. Meyer.
Chairperson, yes, we conceded, the Commission conceded on a few charges not to oppose them, specifically those emanating from her work done in Johasa. But the 4 remaining, or the 5 remaining, it's actually 6 remaining charges are regarded as so serious as to remove her from office. It still warrants and justifies her removal from office. And then with regard to the act, she is actually a chief magistrate, and the chief magistrate of Kempton Park doesn't go to court. There's someone acting in her place, so that would be a burden on the department's budget. But for the rest, she doesn't go to court. She never did go to court. She's actually a manager, and therefore the other magistrates, all the additional magistrates, they will perform the court functions. So there's no problem with the performance of the courts serving the community.
Mr. Mayor.
It's very brief.
No, those magistrates would have to do her work, her managerial work, and do their judicial function. It's an added burden on them. And if she was there doing her work, they would be focusing on what they are supposed to be doing. And just as a follow-up, why did it take so long for the Magistrate Commission to now concede quite a number of charges to be not to oppose them after, because this matter has been going on for some time?
Yeah, well, that was our legal team and the liaison with her legal team just to narrow down all the points in dispute and to limit the disputes so that we can have this review application dealt with as soon as possible. But Chair, I'm still like I said, she was a manager, and there is someone acting as a chief magistrate in Kempton Park doing her work, her overseeing role as a chief magistrate. The additional magistrates are still performing all the court work. The cluster head of Johannesburg is assisting in that regard.
So the cluster head is doing his or her work in Johannesburg and in Kempton Park.
Yeah, now the cluster head appointed one of the senior magistrates in his or her district in the cluster to head the office. And because she's not a cluster head, she's a sub-cluster head, and she appointed a senior magistrate to act in that position to head the office in Kempton Park.
So that magistrate is now acting as a manager.
That's correct. And in the post of chief magistrate, acting chief magistrate.
And then what is happening to the original duties of that magistrate who's performing them?
Well, then someone has to also, of course, be acting in her position, or they can leave it vacant, and then the chief magistrate or the chief magistrate in Johannesburg has to deal with those issues as well.
And that would not have happened if she was in office.
Yeah, apparently she's now, there's still someone acting in her place as well, because he's at the moment busy with meetings.
I'm saying if the magistrate Van Schalkwyk was in office, all of those things would not have happened. There would be no acting for her. So people would be doing.
Of course. No, I agree, of course. Yeah.
Yes.
But that's why she's been provisionally suspended from office.
Okay, members, any comments or views? What do we say with respect to the briefing that we have just received? Do we proceed with the removal, recommending to the National Assembly that she be removed, or Honorable Mwala?
Well, thank you, Chairperson. I think if we are to make a balance between what was presented to us in the past 5 magistrates that we removed, I think this is the worst case. It has got all the aggravating circumstances and the aggravating facts. Given even the fact that the NCOP itself has already proceeded with the removal decision. So I wish to propose, Chair, to the committee that we proceed to the House and recommend that Magistrate Van Schalkwyk must be removed from office. Thank you very much.
Thank you very much, Honorable Mwala. Honorable Horn.
Yes, Chair, I think we must be, and I think you verbalized all of the considerations quite correctly. We must find a balance in dealing with these matters, specifically if there is then pending review processes that is to unfold. We must find a balance between the rights of the magistrate in question versus the right of the public and the interest we have in ensuring that the administration of justice be secured at all times. And in that sense, the whole issue of no prejudice being suffered to the state is then, I want to say, spotlighted from another angle. And I want to say that there's a flip side to that argument from Ms. van Schalkwyk, in that, of course, she would also not be prejudiced if we proceed now with removal. If she ultimately wins the day in court, she obviously would be restored to office retrospectively, and there would be no prejudice for her. But for now, we must put our faith and trust in the processes that has unfolded. We must accept the assurances of the Magistrates Commission that even when they have conceded on some of the charges brought and findings of guilt, that the balance would remain strong enough to warrant removal from office. And on that score, and specifically embracing our responsibility to ensure the proper administration of justice, I believe I must second the proposal by the Honourable Ngola.
Thank you very much, Honourable Horn. The proposal has been seconded. Any contrary view? None. The proposal is that we should recommend to the National Assembly that Ms. van Schalkwyk be removed from office. A report will be prepared. By when should we? By when can we receive the report, Christine?
You can get it by tomorrow morning, or it'll be circulated later today for consideration tomorrow, if that suits you.
Thank you very much, Ms. Silkstone. So tomorrow, before we proceed with the NPA, we will adopt the report, or we will vote on the report, and then it will be transmitted to the programming committee to program it for it to be considered by the House. Thank you very much, and thank you, Mr. Mayor, for the briefing. We shall proceed accordingly.
Thank you, Honourable Chair.
Thank
May
you
I be
very
excused?
much. Yes.
May I be
yes.
excused? Thank you.
Yes. Thank you very much. Can we go back to Mr. Roberts? I think he has had time to get a breather. And can we proceed?
Thank you, Mr. Chairperson. Let's try to shorten the whole presentation, try to group it together to some extent. Comments were received in respect of the definition of prescribed quantity, commercial quantity, and trafficable quantity. The main concern here was raised by the Department of Defense, namely that the current definitions provide for a quantity that exceeds the prescribed quantity in the schedules that regulate traffic quantity and commercial quantity. The recommendations is to the extent that it should relate to a specific quantity and any quantity in excess thereof. Proposed definitions that may be considered in this regard is indicated on pages 25 and 26. And that is to the effect that we recognize that the specified quantity in Schedule 4 is either a trafficable quantity or a commercial quantity, and then give effect to the fact that it's any quantity in excess thereof. it was indicated, amongst others, by the Department of Defense that consideration should be given to the effect to include the relevant schedules in the substantive provisions of the bill. I do refer to Thornton, Authority on Legislative Drafting, to indicate that aspects that is not particularly of interest to the main subject matter of articles should rather be included in the schedule. So our proposal is to the effect that we should stick with the current approach and deal with the quantities in the schedules to the bill. The next comment relates to the so-called arbitrary determination of the quantities. And it's indicated that similar restrictions do not apply to tobacco and alcohol. Our response thereto is to the effect that the prescribed quantities provided for in Schedule 3 regulate the limitations of what is allowed in the bill, and that gives directly effect to the Prince judgment. And the so-called arbitrary and unjustifiable restriction that do not apply to alcohol or tobacco. I must refer, amongst others, to provincial liquor legislation. And I use as an example the Western Cape Liquor Act that actually limit the quantity that may be sold to a person per day, and also limit the quantity that a person may possess. And if a person possesses that quantity, or rather a quantity more than a prescribed quantity, it will constitute an offense. Dealing with commercial activities, Clause 1A is a new proposed provision that aims to authorize cannabis commercialization, subject to the enactment of other legislation. There is certain concerns and recommendations that were made in this regard. First one is that Clause 1A states the obvious and should rather be deleted. I must refer to the significance of Clause 1A, as well as the fact that legislation that must be promoted must give effect to, and the main authorization that is provided by Clause 1A, if read with Clause 1A2, is to the effect that the bill do provide for authorization to regulate commercial activities, notwithstanding our current obligations in terms of the International Drug Control Conventions. So the aim is to more or less indicate that it will be all right if we commercialize, and that's notwithstanding our international obligations. The next more appropriate comment is that of the Western Cape government. It's discussed in paragraph 4.4. It's indicated that there's a need for a less piecemeal approach and a more encompassing legal framework to regulate cannabis, and which take into account everything that need to be regulated in respect of cannabis, and that such legislation should be used as initiative to uplift communities. Well, it is acknowledged that legislation that deals with recreational cannabis activities can regulate each and every aspect thereof. But one must take into account there's a current resultant de facto or legal position that resulted from the Prince judgment that is not regulated at all, or only regulated to the extent as provided for in the judgment itself, which does not address each and every aspect that is required to regulate such legal position. And the aims of the bill is then to regulate the de facto legal position and provide a legislative framework in which the right of privacy in respect of cannabis can be enforced. It was previously indicated that this is substantially similar to a legislative approach in other countries. But yes, to a large extent, it is preferable, or rather not preferable. Let me rather put it in this way. Even if there is commercialization of cannabis, the various limitations provided for in the bill will in any event also be applicable to commercialization to regulate the right of privacy or the private use of cannabis in terms of that all-encompassing legislation. There's a remark by the Western Cape legislature or government to the effect that clause 102 is really not necessary. The legislative competence of Parliament to pass laws is already regulated by the Constitution, and it's not necessary to authorize Parliament to again pass legislation. And this is acknowledged, and suitable amendment will be proposed in this regard. Paragraph 4.6 indicate that a legislative framework for legalization should consider upliftment or empowerment of previous disadvantaged communities to participate in such activities. Our submission is that the bill cannot, by virtue of clause 1A, prescribe Parliament that legislation must be enacted to provide or empower such communities to participate in a certain manner in activities that is authorized in terms thereof. Paragraph 4.7 indicate that the reference to harm reduction and to other measures that is specified may adversely impact on commercial activities, and alternative wording is proposed. Our submission is that even if you look at tobacco and alcohol legislation, the need for harm reduction and certain limitations on what is authorized in respect of commercial activities is limited. There is in paragraph 4.10, there's an indication that rather proposed amendments that regulate commercial activities flows from an improper, unlawful interpretation of the duty of the department to implement the Prince judgment. and that the bill should already have implemented a full extent of measures that recognize each and every aspect that is applicable to the rights interpretation in terms of the Prince judgment. Our submission is no, the bill gives directly effect to the Prince judgment and cannot be interpreted much broader. That is already discussed. Paragraph 4.11 is quite can be considered in this regard. It is indicated that a complete ban on advertising would stifle consumer education regarding safe, responsible use, and as a means to implement harm reduction measures. That is provided for in section, or rather clause 1B3, must refer amongst others to the Tobacco Products Control Act, which prohibits advertising or promotion of tobacco in toto. However, if one looks at section 9 of the Liquor Act, there is only certain restrictions on advertising. Since clause or subclause 3 is only, or rather only aims to prescribe certain considerations that must be taken into account. Paragraph E thereof can probably be amended to the extent that such legislation should consider the prohibition or restriction of advertising or promotion of recreational cannabis. And that can be used to cater for the concern that is raised by the commentator. Paragraph 4.12 indicated amongst others that we must address medicinal cannabis use as well. In terms of clause 11, or rather clause 1A, and it's our submission that we cannot deal with medicinal cannabis in terms of clause 1A of the bill. This is already regulated by other legislation, such as the Medicines Act. There is various commentators propose certain amendments to clause 1A to the effect that obligations are imposed on, amongst others, the Minister of Trade, Industry and Competition to introduce legislation within a certain period. It's our submission that clause 1A should not be prescriptive regarding the enactment of legislation and place certain obligations on other ministers or departments to within a certain period to implement legislation in this regard. It's a complex issue. It was already discussed in a committee regarding the implementation of the Drug Master Plan and the various considerations that needs to be considered, as been indicated already. The South African Medical Association, amongst others, indicate that they, similar to the World Medical Association, oppose recreational use of cannabis in toto. And they do indicate that there is risk, health risks amongst others, on the use of cannabis, and it may give effect to, amongst others, motor vehicle accidents. And they also indicate that it must be strictly regulated to control access to cannabis. And they did indicate that evidence currently regarding the position in the United States of America is that there is an increase in recreational cannabis use amongst the youth as a result of legalization. And they also refer to the alcohol and tobacco current position in South Africa, that there should be strict regulatory measures regarding marketing and promotion, not to entice minors to use cannabis. What we can say in this regard is that the concern is noted. It was indicated previously that commercialization can be used as an effective means to regulate the harms of cannabis. This must be considered in the light of the de facto legal position as the bill aims to regulate vis-a-vis additional measures that can be used to reduce cannabis harms. It's already indicated that the bill will apply in addition to commercial activities. And some of the concerns of SAMA is already addressed in clause 1A3, that amongst others indicate that certain considerations must be taken into account in the recreational authorization of cannabis. Aspect that was previously already discussed and to a large extent considered by the committee is that other jurisdictions set an age for access to recreational cannabis above that of 18 years. SDLD, among others, referred to America, where it is 21 years. Must refer to Canada, although the federal legislation provides for 18 years. The various provinces have in their legalization legislation specified ages that is above that of 18 years of age. It's again stipulated by SAAI that, amongst others, the failure to provide for cannabis legal activities will, in effect, actually give rise to illegal activities, since you provide for a right to use cannabis, but do not provide for legal means to obtain that. And they refer, amongst others, to the commercialization of cannabis and the USA and the substantial income that is generated thereby, and they indicate that South Africa, and similar to the USA, also benefit from this. This is noted, and it has been discussed previously in the committee in the various options for cannabis regulations that can be used to implement commercialization. Is there any questions regarding this, or can I proceed? I'll continue then.
Proceed. Proceed. There are no questions as yet.
Clause 1B provides for special measures to accommodate cultural and religious organizations. The first indication is to the effect that a permit system that is allowed for to accommodate cultural and religious communities is not necessary for agriculture commodity. Our submission that unless cannabis is otherwise regulated, the bill will apply to cultural or religious communities, and unless they are excluded by the special measures, conduct in respect thereof will be criminalized. Obviously, this special exemption regarding cultural and religious communities cannot be regulated similar than alcohol and tobacco. There's indication that this clause, they call it give rise to additional red tape, and it will place obligations on the South African police to enforce this, which may be problematic. The explanation is already provided to extend that a bill in its current form will apply to cultural and religious communities unless this clause regulated further. And although I do discuss different judgment here, which the provisions aims to give effect to, it is indicated that there is a measure of self-regulation that is imposed on cultural and religious communities to implement and enforce the measures in this exclusion themselves. That takes place, amongst others, through authorized representatives of the cultural and religious communities, and that the so-called resources strain on the South African police services is to a large extent addressed this through this measure. There's an indication that in paragraph 5.2, and which also stipulate the big problem that clause 1.3 aims to address, is that according to the commentator, cultural and religious use of cannabis is something that is commanded and directed by the Almighty God and ancestors, and it cannot be regulated by man-made laws. It is indicated that freedom of religion and the rights of cultural and religious communities is a right that is entrenched in the Constitution. It's, however, subject to limitations, and the bill will apply to safeguard persons against the harms associated with cannabis, unless their rights is accommodated in terms of clause 1B. And it is my submission in light of the judgments of, amongst others, Christian education versus the Minister of Education, Prince judgment, freedom of religion of South Africa judgment, that it is possible to further regulate the availability of cannabis in terms of this provision, and this will not amount to unjustifiable limitation of the protected rights in question. Paragraph 5.3 is mainly textual corrections that is proposed, and most of this will be accommodated in further amendments. There is a suggestion in the end of paragraph 5.3 that consideration should be given to alternative punishment options, such as, amongst others, community service or non-custodial punishments other than fines and imprisonments. It's our submission that in the context of clause 1B, to the extent that it do criminalize the conduct of persons, it may be problematic to provide for non-custodial punishments other than fines or imprisonment. Important aspect that must be considered is portrayed in paragraph 5.4, which indicate that broader consultation with cultural and religious communities which may be affected by this provision should take place. Well, this is noted, and there is probably a need yet again to further consult on this aspect. But on the other hand, there was ample opportunity for the stakeholders concerned to make submissions to the department. And if the bill is adopted with this provision, there will be a further consultation process in the NCOP, which can accommodate this. And in paragraph 5.5, it's indicated that there is definitely a need for this clause, since the prescribed quantities for personal use can be used to accommodate cultural or religious purposes. And the clause precisely aims to address this aspect. There is a proposal to the effect that the Rastafarian nations should be authorized to self-regulate cultivation, possession, and supply of cannabis by its members. To extend clause 1B, do allow for self-regulation, but that is subject to the limitations, requirements, and other limitations thereon that may be imposed through the permit system in terms of clause 1B. And it's submitted that we cannot allow for complete self-regulation by the Rastafarian nation. It was previously and also during the public submissions indicated that it should be a once-off registration. It's my submission that, yes, it's only a single application for a permit, and you do not need to renew that on a yearly basis. Aspect that is, however, not catered for in the permit system or the current clause 1B is the aspect where there's religious or culture events that takes place on a place that is not specified in the permit. This is not covered by the permit system or the current clause 1B. The Jamaican legislation do provide for this, and this will be considered, and amendment to this extent will be proposed. There is an indication in paragraph 5.7 to the effect that it's paragraph 5.7c, that in terms of the Rastafarian religion, there should be no restrictions on church grounds and places of worship, since it accommodates all and allow access to anyone. And it's our submission that there is allowable restrictions that can be imposed in this regard. That is, amongst others, to ensure that persons who is not authorized to be at that place can be excluded therefrom, amongst others, certain instances where the person is a minor, and it also limits access to cannabis at such place.
Yes, exhibiting.
Pardon, Chair, point of correction, your camera and phone is on. Give thanks.
Thank you. My apologies.
It's fine, thank you.
Paragraph 5.8, it's a representation by RAS, it's an organization that promotes the Rastafarian religion, places of higher education. Indicated there is discrimination against members of the Rastafarian members at places of higher education, since they cannot access and use cannabis at such places. Designated smoking areas cannot be used for smoking cannabis, and tobacco and alcohol consumption is allowed on places of higher education, yet cannabis is prohibited. It's our submission that the purposes of clause 1B is to specify or cater for cultural and religious use by a community who may perform actions in respect of cannabis on behalf of its members. Clause 1B will not apply in such circumstances. And furthermore, the Cannabis Bill will apply to places outside those specified in the permit. And in general, it's our submission that the prohibition or restrictions that is placed by places of higher education is within their domain to regulate. The bill cannot address this. There's also indication, or rather proposal, that There should be provisions for a religious or cultural cannabis dispensary on campus for members. And our submission is we cannot accommodate this in terms of the bill. The Rastafarian student rights to cultivate cannabis plants on a designated premises, places of higher education cannot be regulated in terms of this bill or clause 1B. And the possession of cannabis in transit from places of higher education to another for Rastafarian events can in general not be regulated in terms of clause 1B or this bill. Must be indicated that we can provide for once-off religious or cultural events in terms of a permit system. But our submission is that in general, the regulation of events at the university is not something that the bill can regulate. This is in the purview of the higher education institution. It's also an indication that members should be allowed to cultivate cannabis for scientific research, etc., on places that's designated by the place of higher education. Again, this cannot be regulated. The bill cannot regulate these aspects. Other legislation already provides for this. There is concerns that is raised by NIMBY in respect of the application of the proposed clause 1B. The first one is how will one distinguish between an ordinary person and a person contemplated in clause 1B. Well, this requires quite a complex explanation of clause 1B. It's mainly to the effect that clause 1B provide that the members of the cultural or religious group must be to an extent identifiable. This is provided for in clause 1B, C5 and 4. That is part of the application that must be submitted, indicating, amongst others, the ambit or the group of people to which it will apply. There's also, in terms of the clause, there's a clear indication that activities must be on behalf of the members of the cultural or religious community concerned. This is provided for in clause 1B7, 1 and 2. And according to the clause, it's probably not necessary to provide for identification of the specific persons who belong to that cultural or religious organization, since it is the authorized representatives that must ensure compliance with this permit. And it's up to them, and they must ensure in terms of the clause to restrict that the cultural or religious exemption to the persons for which that authority is granted on that community. It's self-policing and self-regulation to a large extent. And it can further be strengthened or enforced or clarified by means of regulations. But first, yes, there should be an identifiable group of people belonging to the community. The activities must be restricted to such members, and it is mainly placed on the representatives of the community to ensure compliance. Under cultural or religious exemption, it's indicated that the position or the use of cannabis by traditional healers has not been considered. It's also mentioned that clause 1B of the bill entitled cannot provide for this. Insofar as it relates to traditional healers, it's indicated that the Traditional Health Practitioners Acts must regulate this aspect, and the bill cannot deal with this position under clause 1B. Other more appropriate comments that can be discussed in this regard, so among others, the fact that there is objection to the prescribed quantities. Sorry, let me rather rephrase this. It's again indicated here that there is a need for additional quantities for ritual purposes in excess of the prescribed quantities. It's already indicated that the bill aims to provide for this. There's incidental amendments that is proposed to the long title, and obviously also the arrangement of sections. This will be accommodated in a subsequent redraft of the bill. You must remember that clause 1A and 1B and 2.4 was inserted in the bill without making full and consequential amendments to the bill. FTA again refer amongst others to the fact that it's going to be impossible to identify members belonging to a cultural or religious organization. That has been addressed previously. There's indication that rather it is indicated that clause 1B is unconstitutional. We did previously discuss the Prince 1 judgment. That's Prince versus the President Law Society of the Cape of Good Hope. That, amongst others, related to the use of cannabis for religious purposes by Rastafarian. It was indicated that a majority of the court held that the absolute prohibition was justifiable on the basis of, amongst others, the need to protect others against availability of harm associated with cannabis, and to ensure adequate enforcement thereof, and that it will be impossible to identify cannabis that is to be used for religious purposes. That was the majority court ruling. It was also indicated that Judge Noble Sachs and Mogoro and mainly Judge Nobu held that to not accommodate the Rastafarian religion are inconsistent with the Constitution, since allowances should be made for cannabis use for religious purposes by a Rastafarian, and this can be accommodated through appropriate exemption, and this is what clause 1B aims to achieve. Paragraph 5.50 indicate, amongst others, that there is health problems associated with cannabis, and in terms of section or clause 1B7A3, measures that protect children against cannabis should include provisions that is applicable to pregnant or breastfeeding women. I think this aspect was previously discussed in the committee, and there's an indication that it's a complex matter and it can not be effectively be regulated in terms of the bill. Paragraph 5.16 provides that, or rather suggests that recreational cannabis clubs can be accommodated in terms of clause 1B. Cannabis recreational clubs was previously discussed, and it was indicated that it has an advantage, amongst others, to cater for persons who cannot exercise their rights in terms of the Constitutional Court judgment, due to the fact that they don't have access to a place to cultivate or smoke cannabis, and that cannabis clubs may accommodate this. It was already indicated that there need to be regulatory measures in place to accommodate such clubs, and it's our submission that this cannot be accommodated in terms of the bill. There is further discussion of clause 1B by Tron and Troan, amongst others, again indicate that consultation is necessary, or that this clause must be consulted and workshop, and that extensive consultation must place on the application of this clause with all the applicable stakeholders and communities involved. It's again indicated here that the Rastafari people should rather be allowed to self-regulate cannabis for religious purposes. But it's also indicated in paragraph 5.7 that the organizations in question will, during the NCOP process, more actively, or rather become more actively involved in relation to the provisions of the bill, as well as this provision that accommodates Rastafarian people and cultural and religious organizations. So there is indication that in paragraph 5.18 that quantitative limitations should be set, and we agree with this. Clause 1b specifically provide that the quantitative limitations is those quantities of cannabis and cannabis plants that is required for religious and cultural purposes only, and that it may be limited in terms of a permit or in terms of regulations that may be made part of the permit that the minister may make. The minister may make in terms of clause 1b. Paragraph 5.19 can indicate that this clause may be unconstitutional. I've already discussed the Prince judgment and the context in which the clause is proposed. The kind of recognition that a constitutional court already gave to the right of Rastafarians to exercise their rights. This is as far as I can go at this stage. I can go further, but the other document is in a very rough format. Thank you.
Thank you very much, Mr. Roberts, and to your team for the work done. Members, are there any questions or comments? Honorable Horn.
Yeah, thank you, Chair, and thank you for the presentation. Chair, we obviously are faced with the difficult situation that through this presentation, it's quite clear that certain amendments is to be made to the bill by the department in reaction to the further comments that were made during the second round of public participation. And obviously for us to properly engage with the bill, I think we will need sight of those amendments. However, to assist that process, I just want to maybe request or interrogate a few matters. I've noted both the comments that some legislative amendment or amendment to the bill is on its way, both in respect of the preamble and specifically the way the Rastafarian community is singled out there. So that's appreciated. I've also noted that the department says it is relooking the whole idea of a prohibition on the procurement of, let's say, seeds. I don't know what the exact term was that we used, that could have a chilling effect on the ability of people to make use of cannabis in a private manner. So I'll await those. 3 additional issues I ever want to raise, and I don't know whether I, to an extent, misunderstood, but is it correct that through the reactions of the department today that for the want of a better term, it would seem that the department is having what I would call second thoughts about the commercialization clause? So I've noted that the presentation today has placed huge emphasis on the fact that the Department of Justice is not enabled or best placed or authorized to ultimately deal with the commercial aspects of this. And is it then fair to say that it is going to be proposed that we rather again withdraw that clause? If not, then I in any event want to say that through the second round of public participation, I don't think the clause is as clear as it could be. A lot of the commentators clearly interpreted the beginning of that clause that reads subject to other legislation to sort of strengthen the prohibition on commercial activity, whilst our understanding was that the whole idea was that this sort of an interim measure. So if it's not going to be withdrawn, I would plead that we in any event remove any ambiguity in respect of this matter. Then, Chair, in respect of the THC levels, I mean, I was hoping that some who would come during the second round of public participation, given the fact that they are objectively speaking, but also in terms of proclaiming themselves to be the subject matter experts, would have assisted us around THC levels in a better way. So whilst we obviously as lawmakers want to work with certainty, I think we must now turn around the whole question around THC levels and ask whether the department is advised as to what the typical THC levels to be found in cannabis vegetation in South Africa would be. We understand that those that TH levels, obviously in respect of edibles and substances subtracted from the plants, could be, I want to say, manipulated. But for us to give proper effect to the Prince judgment, and I'm appreciative of the fact that the department also keeps reminding us that that's our job, I think the important aspect is that it would defeat the whole idea if we ultimately regulate use on the basis of THC levels, which would make private use of specifically plant material virtually impossible because the THC levels is too low. So as I say, whilst then making peace with the fact that seemingly no real scientific information is available to properly guide us, I think the minimum request should be then, what is the typical type of THC levels in plant material in South Africa, so that we can ensure that we're not just acting as if we're regulating, but through that regulation in any event placing prohibition on private use. And then lastly, Chair, in respect of the argument around clubs, I've noted the stance of the department to the effect that this cannot be accommodated via this bill, but I would want to ask for a better substantiated reason behind that. On the one hand, it might be argued that to regulate or allow for clubs could, in theory, go further than the minimum requirements set by the Prince judgment. On the other hand, it is also so that the arguments around improperly, for practical purpose, enabling use could be valid arguments. And in respect of, and let me furthermore say, if the department comes back with a better substantiated argument, if the answer is going to be that regulation would be difficult, given that all clubs, of course, have executives, so to speak, and that it then would become a regulatory issue around how much then can managers or the executive be allowed to be in possession of in order to enable use by the club. I want to say that specifically the latter part of the presentation, which talked about quantitative limitations, of course, can be used ultimately also, as well as registration of clubs as specifically, let's say, accounting or executive authorities, and having a system in place to specifically identify people who ultimately could be allowed by way of transportation and possession of higher amounts than that allowed for private use, to enable clubs to properly function. So the essence of the request is basically that the department give us a more substantiated reason why it believes the whole issue of clubs for private use cannot be accommodated. Thank you, Chair.
Thank you very much, Honorable Leeward Johan.
Thank you very much, Chair, and thank you for the presentation. I don't want to say much now until I have gone through the document in its entirety and absorbed it, because as the document only arrived this morning, so I didn't have enough time to go through it in depth. So I've just listened to the presentation. However, I am struggling to understand the part where Mr. Robertson is saying, I mean, I don't expect a response now, but I would like to get a better understanding when we're going through clause by clause. The part where Mr. Robertson says that this bill still criminalizes, it doesn't decriminalize cannabis. So the bill only gives effect to the Prince judgment. So the Constitutional Court didn't decriminalize cannabis. So in terms of that, I would just like to find out or clarify that when Parliament passes this bill, does the Prince judgment fall away, or because the Prince judgment instructs Parliament to, to do certain things. So once the bill is passed and becomes an act and gives effect to the judgment, I'm very confused about that part. Maybe my confusion is because I am like other citizens in South Africa, also not clear on how the Prince judgment and the bill and the criminalization, decriminalization, how that all works. So if I could just get clarity on that, Chair, thank you.
Thank you very much. Mr. Robertson.
Thank you, Mr. Chairperson. Regarding the decriminalization and continued criminalization, I want to refer to paragraph, I think it's 1.1.b of the presentation, and it is indicated that the Prince judgment declared the prohibitions in respect in the Drug and Drug Trafficking Act, so far as it relates to the private cultivation, possession and use of cannabis unconstitutional. Then, amongst others, by way of read-ins, rectified the provisions inconstitutionality, and they then indicate, among others, or rather clarify its judgment further, amongst others, that private space and private use, etc., is that for adults' own purposes, must not be in public, and must not be in the presence of children. And the legislation that gives effect to that judgment is obviously the bill. Clause 2 of the bill respects the right of a citizen to possess cannabis, cultivate cannabis plants for private purposes, and in line with the Constitutional Court judgment, it prescribes certain quantities. So in that context, the bill do legalize the use for private purposes. However, the other provisions of the bill, clauses through to 6. Amongst others is certain limitations that is imposed on the right of adult person in terms of the Constitutional Court judgment. And that is obviously to enforce the prescribed quantity limitations and to provide for additional aspects in respect of the, let's call it the legal position that resulted from the Prince judgment, to regulate other aspects that needs to be regulated to protect others against harm. The Constitutional Court judgment is in respect of the right of privacy, and it rightly decriminalizes cannabis private use for adults. And the bill is not contrary to the judgment. It do provides respect that right in clause 2. Criminalization must be seen in the context of the limitations that is imposed by the other clauses of the bill to regulate this right of privacy. Cannabis will be decriminalized in terms of the bill. That gives effect to the judgment. It's probably, let's call it unintended use of words, but criminalization must be seen as attended to the limitations that is imposed on the right of privacy. But regarding the further submissions that were made regarding cannabis clubs, countries that do allow this is, amongst others, Uruguay, Netherlands to an extent. There is some US states that do allow for that. Legislation of other US states, or most of them, do not prohibit it, but also not specifically authorize the use of cannabis clubs. It's correct that there is certain, let's call it, the discrimination that may result in terms of, amongst others, clause 3, which limits the cultivation of cannabis plants to private place, and also the restrictions that is imposed on where cannabis may be possessed in terms of clause 4, and also the restrictions relating to the consumption and use of cannabis in terms of clause 5. And that relates to persons that obviously don't have a place to exercise that right or to consume cannabis. There is indications that, or rather, let me approach it from this way. Cannabis club regulation would, amongst others, authorize the memberships, how many people may belong to a cannabis club, how many plants may be cultivated, how many cannabis may be obtained by members of that cannabis clubs, may be used as a venue for consumption of cannabis, and other activities in relation to cannabis, amongst others, assistance amongst members to cultivate cannabis plants. It's my submission that regulation is required for that activities. If one looks at the submission, amongst others, of FGA, which I discussed in the beginning, there's an indication that, yes, cannabis clubs already functions in South Africa to an extent. There is a code that regulates the actions, and the code even goes far as to, amongst others, impose limitations to address certain harms. But even in terms of FGA's presentation, there is indication that government must provide for the further regulation of this, and that government should be responsible for this. I want to refer to a recent or a pending court case, amongst others, where a person through the internet receive orders and seeds on behalf of others. They cultivate the cannabis plants in a certain place, and then they harvest the products and then provide it to back to the members that actually place, let's call it an order. My submission that such aspect is very loosely regulated, and it actually allows for illegal activities to take place. There is more restricted models that can be imposed, where there is a clear membership, where there's identified persons that belongs to that cannabis club, and that restricts its operations or activities specifically to members. But again, if we do not regulate cannabis clubs to some extent, it do open up the opportunity for criminal activities. Amongst others, if I am caught with, let's say, 99 plants, as is allowed in terms of Uruguay's cannabis club implementation, and I tell the police we are actually a cannabis club, and there's no legislation or regulatory measures to back it up, it is going to give rise to enforcement, law enforcement, or enforcement at least of the bill, to effectively restrict and regulate the accessibility of cannabis clubs. It is possible to provide for legislation to that effect. And it just depends on whether the bill itself is an appropriate instrument to take that forward. In light of the fact that the Department of Justice itself cannot actually administer cannabis clubs, it cannot enforce measures. It haven't got a capacity to do that. Submitted that other departments is in a better position to regulate this and enforce this. I must take due notice of the remark in the Prince judgment, where it stipulated that any activity of an adult in relation to the cultivation of cannabis plants. Insofar as it relates to the cultivation of cannabis plants for that adults' own purposes should not be criminalized. There were submissions and arguments previously during the previous consultation process, and even in terms of the current submissions that we received, that indicate that it can be accommodated in that regard. And obviously, yes, there is discrimination if you restrict a person who cannot comply with the privacy cultivation measures, or don't give a person an opportunity to consume cannabis in private. That can or may amount to a constitutional issue at some stage. So mainly due to the fact that if there's not adequate regulation, it may be used for unlawful purposes. And furthermore, due to the fact that the department itself cannot actually administer any legislation or regulation that gives effect thereto, it will be problematic for the department in this bill to specifically provide for cannabis clubs. I hope I did clarify that adequately.
Sorry, Honorable Msimang, your hand is noted. Can you switch off your mic?
Regarding the THC content of cannabis in South Africa, I think I already clarified the hemp issue, but the bill do not want to provide for that. Other legislation must provide for that, and obviously it must take due cognizance of South Africa's climate, etc., and it must then prescribe a THC limitation, which is appropriate in South Africa's circumstances. Outside hemp, and with reference to the definition of cannabis, I must first indicate that some of the submissions that we receive indicate, amongst others, that the general content or THC content in cannabis plants in South Africa is more or less between 3 and 7% THC. There's other submission that indicate that is between 2 and 5%. If we do consider the current definition of cannabis, especially paragraph B and C, the first part, amongst others, deals with a cannabis plant, where it indicates it is the fruit or flowering tops. Paragraph B then deals with any substance containing THC. Previously, a limitation of 1% THC was proposed. During the previous process on the bill, it was increased to 2%. But additional limitations were then imposed in respect of other sections of the Act, which will accommodate for a lower percentage of THC. So the 2% of THC that is proposed in paragraph B obviously do impact on paragraph A, the cannabis plant, and it can be interpreted to the effect that the cannabis plant will only be regarded as a cannabis plant for the definition of cannabis if it has 2% THC. But as was indicated previously, it is rather an arbitrary amount that is prescribed considering various circumstances, and the need to also provide for THC products, edibles, consumables, or concentrates. My submission is that we can probably consider to reduce any substance containing THC to the previous 1%. And alternatively, to keep the present 2%. We cannot give specific or cannot accommodate the specific recommendation that any substance must be a substance, let's say, about 3%. I must also look at the fact that one must look at a psychoactive effect or a narcotic effect of cannabis, and submitted that 1% THC per volume may already be quite substantive and have a narcotic effect of a person, which do warrant its limitation in terms of clauses 3, 4, and 5. And obviously, in respect of children, a lesser quantity of THC is required. That is probably as far as I can take the THC quantitative limitation in this regard. I will try to obtain further information and consult with subject matter experts on this provision to provide a more clear indication on the limits that is required to produce a narcotic effect on a person. That may aim to clarify the percentage of THC that must be prescribed or determined in paragraph B of the definition. And paragraph C may then also further be clarified if we've got a sure indication of the psychoactive effect of the THC quantity on a person. Regarding commercial activities, it's correct. The Department of Justice cannot commercialize or promote legislation for such commercial activities. In terms of the current clause 1, 2 of the bill, there is provision that other legislation may, amongst others, regulate certain activities in respect of cannabis cultivation material, cannabis plants, and a cannabis product. And it was previously indicated that this was an attempt to already accommodate commercialization in terms of the bill. was also previously indicated that that clause was subject to criticism by, amongst others, the Department of Health, Agriculture, Department of Trade and Industry, to the effect that it does not provide a clear authorization for commercialization. I think their concerns relate to our international obligations in terms of the drug control conventions. Clause 1A aims to provide that authorization. Although that authorization is subject to the promotion of other legislation, it is a clear indication that, contrary to our international obligations, commercial activities may be undertaken in South Africa for commercial purposes. And that is the main aim of clause 1A. It's further to clarify the stated object, even in the objects memorandum, and I think it's the long title of the Act, that it do provide for commercialization of cannabis. So, I don't know if, well, let's rather state it in this manner. Clause 1A just further clarify what is already stated as one of the intended objects of the Act. It just further clarifies that authorization or commercial activities that may be undertaken. I don't think it falls outside the intended initial objective of the Act. So there's no U-turn on that issue. It stay as is. Regarding commercialization and subsequent legislation that must be promoted, I think it's already catered fully to a large extent in policy documents. There was a cabinet decision in 2019. The Cannabis Master Plan gives effect thereto. To an extent, hemp cultivation is already implemented through the Medicines Act and regulations made thereunder. And clause 1A, therefore, just further cater for commercialization. It is acknowledged that clause 1A need to be cleared up. I think the main concern against 1A is to the effect that we do not need to state that or rather that other legislation need to be promoted in clause 1A2. As I stated in the Western Cape government submission, we do recognize that clause 1A2 is not needed. However, clause 1A is needed, and the current 1A3 that states certain considerations that must be taken into account. It's not a must, and it's not as a restriction on subsequent legislation. It merely gives an indication of what needs to be considered in such legalization. So the only real proposed amendment that is accommodated is to clarify the reference to the legislation in 182. That is removed. Regarding seats, yes, it was indicated previously that it may be considered to remove the limitations on the availability of seats. Currently, in terms of clause 2, seats may be distributed without remuneration amongst others, amongst adults. But it does not provide specifically for, amongst others, the buying of seats. Although adult person may possess unlimited quantities of seeds, there's restrictions on the distribution thereof. Commercial activities in respect of seeds serves a wide, rather, any intended commercial activities of seeds in some countries are strictly regulated. And the reason, therefore, is obviously to restrict it to certain cultivars that has got a safe amount of THC, to ensure that it is distributed through a approved outlet. And to some extent, it also ensures that the substantial revenue that may be created through the selling of seeds is appropriately taxed and regulated more or less to obtain some kind of benefit to address the harms of cannabis that is cultivated in respect thereof. The bill itself,
yes,
my
can
submission.
you round up, Mr. Dupree, Mr. Robertson?
Sorry, Mr. Chairperson. My submission is that commercialization of seeds should be regulated by the other legislation that provide for the commercialization of cannabis. I think that's all I hope. Thank you.
Thank you very much, Professor Msimang.
Thank you, Honorable Chair. My concern is with regard to way forward. We have been listening to the report telling us that the bill has been rejected. And the question is, what now? What options do we have? There was the first option to take the bill back for amendments. And the report says that after amendments, the bill actually got worse. So what options are left for us to consider to save this bill? Thank you, Chair.
Thank you very much, Honorable Msimang. The bill has not been rejected. Those are the views of the department. We are still going to consider the bill clause by clause. We're still going to revisit the bill clause by clause. Those are the responses from the public hearings, and that is those are the views of the department from the views expressed from the public hearings. But do you want to say something, Mr. Robertson?
No, Mr. Chairperson, it's just to confirm that, yes, it's correct. It's mainly submissions that were made to the effect that from stakeholders or persons that participated in a public process that regard or rejectable on that basis. I don't think from our side, I don't think there's an intention to withdraw the bill. It's in the parliamentary process and it's subject to due consideration by Parliament.
Thank you very much. Thank you very much, Mr. Roberts. Are you covered, Professor Msimang? Professor Msimang, are you covered? Okay, thank you very much. Thank you very much, members. I think we will now proceed, not now. The next step is to proceed to consider clause by clause processing of the bill, taking into consideration the responses and the public hearings that have taken place. Can the department now proceed to put in front of us for consideration a bill that has got clause by clause, which we will consider as the committee? Is that in order, members?
Yes, Chair.
Yes, Chair.
Thank you very much. Mr. Roberts, how long will it take you to have that bill ready for it to be considered by the committee?
Mr. Chairperson, with due consideration to my workload, it will probably take a month, but let's say within 10 days from today is probably a reasonable period. It must be indicated that some of the submissions have not been discussed, but that will be accommodated and considered in the finalization of that text. From my side, I will please ask for 10 days. There's other legislation that is equally important, and that's amendments to the Drugs Act that needs to be finalized. So 10 days, please.
Thank you very much, Honorable Breitenbach. Your hand is up.
Thank you, Mr. Chair. Yes, I hear Mr. Robertson in the 10 days. We should bear in mind that Mr. Robertson is still recuperating and we shouldn't put too much pressure on him. So the 10 days is reasonable, but if he needs more, we should really give him more. Thank you, Mr. Chair.
Thank you very much. Any other views on this matter? The 10 days would end when, Mr. Robertson? If we have to exclude the weekends?
Mr. Chairperson, that includes weekends, so it's basically 10 ordinary days from today.
Exclude weekends.
No, 10, include weekends, it's fine, 10 days from today.
Let's say on the 11th of this month, already we were planning to conclude meetings of the committee on the 8th. So, sorry, members, is the speaker's phoning. Sorry for that, members. It was the deputy speaker. Can I suggest that we, because already by the 8th, we should be, it will be our last meeting as the committee, that we allow time that when we come back from recess, they would have had time to do all the necessary consultations and the bill would be ready for us to consider clause by clause. Will that be in order?
Fine.
Yes, sir.
Thank you very much. Mr. Roberts, thank you, Mr. Roberts and your team, thank you very much for the work done. We will see you when we come back from recess in August. I think that will give you enough time to do whatever it needs to be done to the bill and to do the necessary additional research that is required. And then we will see you when we come back from recess in August.
Thank you, Mr. Chairperson. Thanks. Bye.
Thank you very much, members. The time is now 20 to 2. Can we have a 30 minutes break and then we come back, let's say 2:15 to receive a briefing from Mr. Dupree on the land court bill?
That's fine. Thank you.
Thank you very much. This is adjourned for now. Good afternoon to Mr. Dupree and to your team. Welcome. Can you take us through the Land Court Bill?
Good afternoon, Mr. Chairperson. Thank you very much. I am most probably going to ask my colleague to take over from me at some stage because I really do not feel well. But I also wanted to say, and just by a slight remark on my side, I'm not an expert on THC, but I think if you keep the THC level under the inflation rate, I think you'll be fine.
No, I think Mr. Horn got a very good answer for his question.
Thank you, Chair. Let's get into.
But on a serious note, Mr. Dupree, we really do not encourage people who are not feeling well to come to work.
Chair, no, it's my work to do to assist this committee. So let's see how far we can get. Mr. Makudubete is on standby. He'll take over from me if I'm not able to finish the job today. But let's get into the business of the day. Thank you, Chair.
It's our work to protect you from yourself.
Yeah, Chair, if no one protects me, then you'll protect me.
Okay, let's proceed.
Thank you, Chair. Mr. Chairperson, we've prepared the working document, and it's our first draft. Unfortunately, and I must apologize for that. It's not a finished product, but it's dated 31st of May 2022. And I would just like to mention to the Chairperson that I am still a bit angry with the ANC government for having taken away that public holiday, the 31st of May, because that's my birthday, Chair.
That is the more reason you should have been at home to look after your health and to celebrate your birthday.
No, that was just by the way, Chair. Let's get into the business of the day. The bill was introduced last year. Chair, I'm not going to bother you with the long title or really the preamble. There's just one addition that we propose at this stage with regard to the preamble of the bill, and that was comments that we received that a reference should also be made to Section 34 of the Constitution, which provides that everyone has the right to have a dispute resolved by the application of law decided in a fair public hearing before a court, or where appropriate, another independent or impartial tribunal. Those amendments are technical of nature. It's just a question of cleaning up the bill as far as we can. And then with regard to the index as well, we'll skip that, Mr. Chair, because at the very last moment, we'll fix that for the committee as well. And then I would like to take the committee to clause 1, which is the definitions clause. In the definitions clause, Mr. Chair, we also received recommendations that it should be made clear that paragraph A and B of the definition of claim should refer or should apply to the Restitution of Land Rights Act. So we propose, or the department proposes, an amendment to that clause. Mr. Chair, I might also just indicate at this stage that, of course, this is a working document, so we'll have to go back and prepare amendments for the committee to approve. So once again, like for example with the sexual offences bill that we brought to the committee, we are working through a working document now, but we will have to prepare amendments for the committee to approve. So this is just to give the committee an indication of where we stand at this stage. And with regard to the definition of claimant, we also restrict that to the Restitution of Land Rights Act. And then, Mr. Chair, this is going to be an interesting one for me personally, because we have received comments that we should define the word day, which is not a public holiday, a Saturday or a Sunday. So in other words, just our normal working days. But we refer to day in the bill just once. So either, and if I remember correctly, it was section 32 of the clause 32 of the 42, where we refer to day. But it might be more appropriate simply just to, even if that word is used only once, to define it, because we might be faced with a scenario in future where the bill may be amended by including days. So we would like to propose at this stage that the word day should then be defined in clause 1. The remaining provisions, Mr. Chair, is quite straightforward. I would like to just take you to the definition of president. You will remind yourself that when we presented the comments to the committee, many commentators, there was a bit of confusion among them. They confused president with judge president or president of the court, but here the word president is defined as president of the republic, and wherever we find the word president, we know that it is the president of the republic. The purpose and objects of the act, I'm not going to waste too much time here at this stage. Like the preamble and the index, it is something that will give attention to at the very last moment of giving birth to this piece of legislation. With regard to clause 3, I apologize, Chair. I'm stumbling over my words as well. With regard to clause 3, it's a technical amendment by replacing the High Court with Superior Court. That is to fall in line with the Superior Courts Act. Then on clause 4, we do not have anything substantial at this stage, as well as 5 and 6. Those are standard clauses, Mr. Chair, as well as clause 7. Please, Mr. Chair, if I'm going too fast, stop me, please.
Yes, fine.
And then with regard to the appointment of judges, we received a lot of comments on that persons being appointed must be broadly representative in terms of race and gender, and then, of course, fit and proper persons who are appropriately qualified. So we have included that. To a certain extent, I could possibly say that we're actually stating the obvious, because those are the issues that the JSC will take into consideration when recommending potential appointees to the president. But however, it's on paper now, so no need to say anything there. With regard to clause 9, and we'll come back to this, Mr. Chair. We just need to try and once again clarify the confusion that existed when we received our comments that with regard to judges being appointed to the court. So the proposed amendment is there in clause 9.3 by deleting those words, who is also a judge of the High Court. Then clause 10, we haven't received any comments in that regard. Clause 11 is also quite straightforward, Mr. Chair, as well as clause 12. With regard to clause 13, Mr. Chair, the institution of proceedings, and this is also a standard clause. The recommendations made by interested parties were that subclause 2 should be deleted. The department agree with that, and the remaining provisions or the remaining amendments are merely a renumbering of that clause. We get to clause 14, Mr. Chair. Nothing substantial there except for the last portion that the department proposes should be deleted. We have received a number of comments where there was also not confusion, but the recommendation that instead of regulations, these type of issues should be provided for in the rules. We are in the process of trying to fix that for the committee, because we agree that issues of how the court should operate, etc., should rather be regulated in terms of the rules. Clause 15 also quite obvious at this stage, and then with regard to clause 16, the recommendation was made that the bill should rather refer to a person or a body with legal standing. The department agreed with that, and we will propose amendments to the committee in that regard as well. Clause 17, Mr. Chair, the whole issue, which is still a bit fluid at this stage, is the whole issue of arbitration. However, it was recognized by the department that the arbitration is a whole issue of parties agreeing to arbitration and then also remitting an arbitrator's decision to the court. those, yes, here we are, one of the classic examples where we are, or the department is proposing to replace regulations with something that must be regulated in terms of the rules. So strictly speaking, Mr. Chair, once again, a technical amendment, but a very important technical amendment. In clause 21, Mr. Chair, also a technical amendment as proposed by one of the commentators, and the department agreed and would like to propose to the committee an amendment in that regard. Clause 22, Mr. Chair. Once again, it's a question of just clarifying that when it comes to hearsay evidence, we only refer to the Restitution of Land Rights Act, and we have advised the committee why hearsay evidence should be allowed in the case of those type of claims, especially because of the fact that they might go back to, if I remember correctly, 1919. So yes, so that is to clarify that hearsay evidence will only be allowed in those cases. Clause 23, we haven't got any substantive proposed amendments, as well as clause 24. With regard to the, Mr. Chair, maybe I should just interrupt myself at this stage and indicate to the chair that yesterday was a very interesting day in our work day. So our document is not complete at this stage, but we will submit a complete document to the committee as soon as possible. So please excuse us for not being able to make your target. So clause 25, no proposed amendments there, except that we would like to say that to an extent necessary, the court may refer any suspicion or allegation of corruption in any proceedings before the court to any relevant authority for investigation. And that was the recommendation that we received, where it was indicated that the court might at some stage find that there might be suspicion of corruption, and that that must be referred by the court for investigation. We might tighten up this provision by maybe saying that, and we'll have a look at this again, but maybe to say that the registrar of the court must refer the matter for further investigation. And then once again, clause 26, the whole issue of consent of the parties. Clause 27, Mr. Chairperson, is a redraft as a result of comments that we received with regard to pre-trial conference. And this is a provision that the committee will soon see in another bill. We are quite satisfied that this redraft will actually do the trick for us. in clause 28, merely a question of semantics that was by the Western Cape government, who indicated to us that we should look at the language being used. And I think subparagraph I is self-explanatory. In subclause 2, merely once again a technical amendment being proposed. And as we scroll down, Mr. Chair, I think we got to the end of what we have for the committee today, except here we have once again the recommendations that it should be clarified that it should be it might be better to refer to the presiding judge instead of the court. I will discuss this with my colleague, Mr. Makurbete, because you will see I've highlighted here in yellow where the two of us need to sit together and decide how we're going to approach that. The recommendation was also made that subclause 10 should be deleted because in fact it doesn't really add value to the bill, and the department agreed with that. And then once again in clause 32, just a technical amendment. Sorry, Chair, I think it might be irritating for you, but I need to, and once again, just...
No, it's fine, no problem.
The whole issue of arbitration, which is still a bit fluid, and then once again, a technical clarification in clause 32(1). And then, of course, the whole issue of the Land Court of Appeal, which the department still needs to report back to the committee on. So we are not able to respond finally in that regard. Mr. Chair, I think I just want to quickly check, but that is the presentation that we can provide the committee with today. I apologize that there's not much more meat around the bone, but that is what the department can do for the committee today. I just want to check. Oh yes, and then of course with regard to the transitional arrangements, clause 51, you will recall that the Land Claims Court submitted or made a submission that indicated that a provision should be made for the existing judges of the Land Claims Court, and that will most probably be included as a subclause 4. Chair, thank you. That brings me to the conclusion of my presentation with your permission. Thank you, Chair.
Thank you very much. Yes. Members, that is the presentation from Mr. Dupree and Mr. Makutubela. That is the work done by the team. I have the following hands: Honorable Nivo Druchan and Honorable Werner Horn.
Thank you very much, Chairperson. And thank you to Mr. Dupree for your presentation. I didn't receive the document, so would you mind emailing it with the highlighted parts, please, so that I can just read through it. But other than that, Chair, I don't have any comments. Thank you.
Thank you very much, Honorable Horn.
Thank you, Chair. Yes, of course, we're thankful for the presentation. In as far as I think it deals with a few of the non-controversial issues raised, but we will then await the department's response and on some of the other matters. May I just on clause 22 around evidence, Chair, ask, my recollection is that during the public participation process, it was the argument of some that it may be necessary to qualify that the mere fact that evidence, which ordinarily based on the rules of evidence would not be permissible or be entered into the record, if that is to be entered into the record, that doesn't take away from the inherent authority of the court to make a determination as to what extent reliance would be placed on evidence entered into the record in such a manner. So I don't know whether the department has considered that specific issue.
Thank you very much, Honorable Horn, Mr. Dupree, and Mr. Makutubela.
Thank you, Chair. I'm going to ask my colleague to also provide you with an answer in this regard, but the bottom line with regard to clause 22 is that we're trying to clarify that when hearsay evidence is involved, the court should have the authority or the power to decide whether that evidence should be allowed or not. The ordinary rules of evidence will always apply. So I don't know whether Mr. Makudubete would like to add something there. Otherwise, we'll, yes, Chair, and I must apologize. Our document was not ready for distribution this morning or last night. So I've noted Dr. Druchan's request in this regard. Thank you, Chair.
Thank you very much. No, we do understand because you had a situation that we were dealing with in the building. We did indicate that to members that you, both yourselves and Mr. Dupree and Mr. Roberts might not have 100% ready documents because of the situation you had.
Thank you, Chair.
Mr.
Mac. Yes, thank you, Chair, and then good afternoon to all honorable members. Chair, this matter, I cannot take it further than what my colleague, Mr. Dupree, has said. We have realized the issues that have been raised by many role players against the issue of hearsay evidence. However, our take is, you remember this specific clause is taken directly from the Restitution Act, that is the Restitution of Land Rights Act. And then we have taken it and then put it in this provision or in this bill. And then we have now qualified it so as to make it applicable only to Restitution of Land Rights Act. Chair, we are not aware of any challenge on this provision as it is currently contained in the Restitution Act. Hence, we were happy to include it in this bill so as to make sure that especially the restitution matters dates far back, as far back as 1913. And you remember, Chair, last week when the department briefed the committee, we did indicate that in some instances, especially in relation to restitution matters, the witnesses or other witnesses might be so aged that they will not be in a position to recall or to remember certain facts that will be of assistance to the court. Hence, now we are saying, let us confine this hearsay evidence only to restitution matters. And also we have that clause that will say the court will only admit those or that hearsay evidence when it is to an extent that is cogent and relevant. And the Chair, obviously then the court will give weight to the evidence or the hearsay evidence so presented to the court. Chair, this is as far as I can take it, and we have taken note of the comments that have been raised against that. Hence, we are approaching it this way by confining it to restitution matters so that all other matters that fall within the jurisdiction of the court do not get to be, or the court do not have to allow hearsay evidence in relation to those other pieces of legislation that come to fall within the jurisdiction of the court. Thank you, Chair.
Thank you very much. Honorable Horn, is that a new hand or an old hand?
It's a new hand, Chair. Thank you. Chair, I accept the explanation in respect of or in as far as it relates on restitution matters. However, section 1 is a section of general application, and subsection 2 then make specifically reference to restitution matters. So I would want to argue that if the intention was to deal here with the special circumstances that may be applicable in restitution matters, then the provision as it now reads is not clear. So that's the first issue. The second issue, however, I want to raise in this regard, and that brings me back to my question at our last session, which I assume the department is still looking into, is the whole question of courts of law and equity. So I would think that the response of the department that the general rules of the law of evidence would be applicable in the case that these courts are courts of law. But if we for a moment then argue that the whole idea behind declaring these courts to be courts of equity is around an obligation on the courts to be part of the program of action aimed at achieving a certain outcome in terms of land, then the courts are no longer, as a consequence, bound by the rules of evidence and the whole obligation around equity would, to my mind, possibly bring into play a situation where the ordinary rules of evidence would no longer apply. So I believe there may be a link between this specific provision and the declaration of the courts to be courts of law and equity. So I don't expect necessarily a full answer this afternoon. I know the department is still, I assume and I hope, looking into what is exactly meant by declaring the courts to be courts of law and equity, but I would think that this must be considered as part of that explanation. Thank you, Chair.
Thank you very much. Mr. Dupree, do you want to comment on that, or you would still want to be given enough time to consider the issue?
Mr. Chair, we can never come to this committee without the blessing of our superiors. My apologies. But I think Mr. Makulubete would like to, at this stage, maybe add something. We are certainly looking at Mr. Horn's request that he made, and we will certainly respond when appropriate.
Thank you, Mr. Makulubete.
Yes, thank you, Chair. I appreciate the opportunity that we are given to come back and then deal with this issue together with the briefing on other aspects. We will deal with it together with in consideration of the comments that have been raised now by Honorable Hall. Thank you, Chair.
Thank you very much. Okay, we can proceed. Are there any further hands on these issues? So I guess the issue of the appeal court, you are still considering it.
That is correct, Mr. Chair.
And the arbitration, the issues relating to arbitration.
Yes, Mr. Chair, and we're also going to respond to the question raised by the committee about expropriation as well. But that is also extremely technical in nature, but we will respond to the committee. Thank you, Chair.
As long as you can expropriate Honorable Dennis Breitenbach's dog, that will be fine. So, so when do you think you would be ready? Because we would want to finish this bill as soon as possible. Will you be ready next Tuesday?
Mr. Chair, we're working in a team. So I would like Mr. Makulubete to also come in here. I doubt whether it's difficult, Chair, to commit to time periods, especially when it comes to the portfolio committee, because we never want to, as officials of the department, we never want to let the committee down. It's difficult to say, Chair. I would like Mr. Makulubete to also maybe provide his input, with your permission, Chair.
Mr. Makulubete.
Yeah, thank you, Chair. I do share the sentiments of my colleague. The issues that we have been requested by the committee to deal with are quite big issues, which we will want to bring to the committee, as Mr. Dupree has mentioned, with the blessing of our superiors. So to commit to a certain deadline,
okay, no, you are both diplomats.
Difficult.
No, we are both diplomats. I think what we need to do, because I know for a fact that you might be having a lot of work in the next term, there are a lot of bills, close to 6, that in fact are constitutional court bills whose deadline, some of them starts in November. So you won't have time. So I think it would be better, let's meet on Tuesday. You will present to us what you would have done. We'll take it from there. Let's commit you to a date. So we'll see what you would have done on Tuesday, and then we'll take it from there. Because the more we postpone a lot of bills, you are going to be overwhelmed come next term.
Perfectly understood. Thank you, Chair.
Thank you very much, Chair.
Yeah,
It's
I know that
understood.
there is a general problem of capacity. Few people are dealing with a lot of bills in the department. So quite a number of bills that have got constitutional court deadlines would need to be finished before November. So even if we can say we are lenient on you on this one, but it is just going to be part of the bills that will be piling up a pressure on you come next term. So let's focus on working and reporting on Tuesday.
Thank you, Mr. Chair.
Thank you, Chair.
Thank you very much. Any issues on this matter, members? None. I think we have to deal with just 2 housekeeping issues. One issue would be last week we circulated a letter from Carls of Wits University with respect to the Cannabis Bill and the proposed response from on our side. I've asked it to be circulated to members so that members can have sight of the letter and the response. A reason being we are dealing with people who are very litigious. We would like a response to be a response of the committee and it be recorded as the response of the committee. So members, have you had time to look at the letter and the response? I know there are quite a few members who have expressed a view that they are fine with the response, but I would like to get a final word from members of the committee, the letter from Carls. Honorable Nivotochen.
Thank you very much, Chair. And yes, I have read both documents and I agree to the response prepared on behalf of the committee. I agree with that letter. Thank you.
Thank you very much, Honorable Nivotochen. Other members? Can I take it that will be our response to Carls?
Yes, Chair.
Thank you very much. Then the next item, members, as you know that the chair of the subcommittee will not be part of us until the 14th of November. I would like to appeal to members of the subcommittee on correctional services to proceed on Friday and elect their chair to chair meetings, because we don't want to have successive postponement of issues that will not be good for our workload, also for the reputation of the committee or of the subcommittee. So can we agree, members, that on Friday we proceed, but you would elect the chair of the subcommittee?
Chair, it's Werner Hoorn. If I may,
Yes.
Chair, I was wondering, given the fact that we are faced for a variety of reasons with, let's say, a frequent diminishing in our numbers, whether we shouldn't, for the immediate future at least, then just rather than dealing with this by way of a subcommittee, just ask the committee members to attend. I can't, of course, speak on behalf of other parties, but from our side, we try and attend with, of course, the understanding that given the fact that it's ordinarily a subcommittee, that if some of us have other responsibilities, then so be it. But ultimately, the correctional services matters remain the responsibility of this committee. So I don't know whether we should, at least till, let's say, we go on constituency period at the middle of June, rather deal with it by way of committee meetings. But that's just a suggestion. Thank you.
Well, so we are suggesting that from now until the 14th, we just combine it as one committee. But after that, when everybody is back, then it proceeds as a subcommittee.
Yes, Chair.
Is there any counter to that, Honorable Nigo? Or any second? Let's first start with the seconders.
Not a counter. I support that suggestion, Chair.
Okay.
I support the proposal by Honorable Hoorn.
Thank you very much. Any counter to that? And none, that is agreed to. Mr. Romano, can you remind members about tomorrow's agenda? Because we will not be dealing with the Cannabis Bill. We would also not be dealing with the land court. The land court has been postponed to next week, and cannabis is until the end of the term. In fact, it will be next term. So tomorrow we have progress report on the NPA, on TRC prosecutions, and I think we also have the adoption of the report on the issue of Magistrate van Schalkwyk. Have you received all reading material for the TRC prosecutions, including the letter from some organization, some human rights organization? Who are saying that they're acting, they have been doing work, yes, and they are representing the interests of the families. You have received that?
Honorable Wilmer says yes, Chair.
Thank you very much. So can we meet tomorrow at 9:30? Is that correct, Mr. Romano?
Yes, Chair, we can meet at 9:30.
Okay. The meeting is adjourned. Thank you very much.
Recording stopped.